4. Vážené dámy,
Ladies and gentlemen, good morning. Welcome at a well-attended seminar. That makes me very happy. My name is Libor Vondráček. I'm an MP, and I have been cooperating with the Šalamoun Association, Spolek Šalamoun, that has been organizing similar events under the auspices of the Constitutional Legal Committee. Let me also introduce my colleague, co-moderator, Mr. Šimon Mach. He's a lawyer. He's also a member of the Šalamoun Spolek, and if I'm not here, he will take over. Such a big attendance shows that law, rights and justice are not always perceived as the same thing. This is why we are going to be dealing with this important question, and we will hear from the experts and top politicians, and I'm very happy that the first one that I can give the floor to is the head of the Czech Parliament, Tomio Okamura.
Vážené dámy,
Ladies and gentlemen, let me welcome you on the territory of the Czech Parliament. Thank you, Spolek Šalamoun, for the opportunity to welcome you and say a few words. Together with the Czech project Innocence, we have been trying to enforce justice into the Czech legal system. Justice is not an easy thing. Unfortunately, very few people realize this, including journalists and politicians. As of today, it is very difficult to enforce justice in the Czech Republic. Miscarriages happen much too often, and Spolek Šalamoun has been documenting these cases. Many such cases are hard to believe and absurd. The prosecutors and courts not only make mistakes, but quite often reject witness statements, testimonies, and such. Of course, honor goes to all the honorable judges and state prosecutors. In this profession, there are honest people and dishonest, like in every profession. This is why we have been rejecting the untouchability of state prosecutors and judges for a long time. All of us can commit mistakes, but everyone should be responsible and liable for their work. This is a principle that we are in favor of for all privileged groups, not only of politicians and the justice. If the justice system commits a crime, this must not be defended as a mere error. Let me thank all the colleagues from the Constitution and Legal Committee for support of this event. Ladies and gentlemen, justice is an important human right. Enforceable justice has been the reason thousands of years ago for the first democracy in Athens. Judges have been drawn by a lot every day, which made corruption impossible. And there were many judges, so they could not be biased. We know, therefore, that justice has had problems always for thousands of years. Without enforceable justice, there is no democracy. Democracy does not depend solely on elections. Elections took place in Nazi Germany and in North Korea. thank you all who are helping us to strengthen democracy and rule of law. This is very difficult because those who are against this are fighting against us. Thank you also for fighting for the sake of victims of crimes. I hope that you will like this time in the Czech Parliament, and thank you once more, organizers and all attendees, for coming to such an important seminar. Have a nice day.
Děkuji.
Thank you for the introduction. And now I will give the floor to Dr. Renata Vesecká. She is the chairperson of the Constitutional Legal Committee.
Vážený pane předsedo,
Dear Chairman of the Parliament, dear guests, ladies and gentlemen, mine will be a follow-up to my speaker, and I would like to thank Spolek Šalamoun for organizing this seminar. All of us know, and you have been attending this seminar for quite a few times already, I'm sure, since Šalamoun has been dealing with the issues of the judiciary and the Czech justice system for a long time, and they need to be thanked for that. I can also say that all of us here, and I'm sure all of you as well, feel that the Czech justice system is not free from errors and mistakes. Unfortunately, these errors and mistakes tend to have sometimes an extreme consequence, not only for individuals, but even for whole families. And therefore, a debate about the justice system is so important. A condition of fairness is always provided by the Czech justice system, but debating the Czech justice system does not mean that we want to challenge independence of the legal system. Independence is not the same as a lack of responsibility, and it does not mean that we would be banned from asking questions. To the contrary, these questions must be raised about all steps taken by the justice system. I'm sure that we will be hearing about the best known controversial cases that deprive the citizens of credibility and a feeling of fairness into the judicial systems. Sometimes contradictory decisions, difficult legalese, and sometimes the fact that the courts decide differently about identical cases. Those are the problems. Sometimes such cases call into question, even years later, whether the state was able to protect the innocent one and to punish the culprit. And at the same time, we also need to wonder whether simple human justice was given a chance. Justice does not equal just a judgment, decision of the court on paper. Fairness and justice is also equal to the path to that judgment. And if that path takes much too long, if it is impossible to understand, or or if it breaks the parties economically and mentally, then the decision came too late, and late justice cannot correct all that has taken place before, all that was bad. When I looked at the topics that we will be hearing about today, I was happy to see that this seminar will not limit itself only to criminal law. We will also hear about the civil law matters. Family law and decisions in family law is as sensitive as criminal law judgments. These are judgments about limiting parenting rights, about custodianships. These are highly sensitive judgments, and one such presentation by Professor Válková will show that the civil law case may be transformed into a criminal one. I'm sure that we will hear many interesting topics about many interesting issues, and it will give the Šalamoun Spolek input for organizing a future seminar like this. I would like to offer one topic that we will not be discussing today, and that is a question of responsibility, liability, compensation for damages for the victims. I think that this is a very current and important topic, and in decisions of courts, sometimes we see that the financial and psychological satisfaction is not granted, and the approach of the Ministry of Justice and the courts are not ideal, far from it. Victims very often wait for years till the state apologizes to them, and sometimes financial compensation fails to cover the costs of legal representation of trials that take years. So that was my proposal for topic for the next seminar. I will unfortunately be coming and leaving because we have a session at the Parliament today with voting, so I will have to run away quite often. I'm sorry that I won't be able to hear all the presentations, but I hope that you will be happy to see that we want to make things better.
Thank you so much, Chair, for mentioning that all of us, all MPs, will be moving between the chamber and this room. So the next speaker is Mr. Minister, who's coming. He's got a meeting at the moment, but he's coming shortly. And after the chair of the Constitutional Legal Committee, it will be the chair of the Foreign Committee of the Chamber of Deputies who will take the floor. So, hello, dear Chair, MPs, dear guests, ladies and gentlemen. I would like to thank the Šalamoun Spolek for organizing this event. Congratulations. I very much appreciate the attendance. It is a huge event, and I will have to get a bottle of nice Moravian wine to the reception because we made them busy this morning. The most popular speaker will be the shortest one, and I want to be the most popular speaker. I've got two personal remarks. Each legislator, each member of the Constitutional Legal Committee experienced the contact or was contacted by a citizen in a desperate situation in criminal proceedings, saying that they contacted the courts at all levels, and I always have to explain from my position of the chair of the Constitutional Legal Committee that we are legislators and we cannot intervene in the judiciary. I am a certified populist by the Czech media, so even I cannot intervene. So last hope that I have is to give a call to Mr. Peričevič and ask him to help us. These are difficult cases. People are convinced that if a next of kin dies, it is claimed to be a suicide, and they are convinced that it has been a crime. Sometimes the last resort is Šalamoun, and I really appreciate their effort. They accept the files, they review the files, and if possible, they give us advice and they help people. They provide mental support because the people who are desperate don't feel alone and lonely any longer. So we should support this, I believe, and this is the civil society as it should be. This is an activity of the civil society. Judiciary is independent, but it is of course not unmistakable and inerrant. It needs control mechanisms. As a chair of the Constitutional Legal Committee, I appreciate that the discussion is taking place in the Czech Parliament. State responsibility and for the miscarriages is important for the trustworthiness of the state. And I am also a member of the Foreign Committee, protection of innocence and looking for ways how to mitigate miscarriages of justice is not a problem of one country. It is a challenge for all democratic countries. That's why I'm glad that I can see Professor Brandon Garrett among the guests today. He focuses on the problems of miscarriages of justice and the right to prove innocence.
Honored to have you here today, and we greatly appreciate your contribution to this important discussion. Velmi si vážím také toho, že se
I very much appreciate Šalamoun's engagement in the international cooperation that establishes contacts with foreign personalities and institutions, protecting innocence and mitigating miscarriages of justice. We have to be open to the knowledge from abroad, and we have to apply critical view on our system. The justice must not be only a declared value, but a functional guarantee for every individual. So I hope that your debate will be bold and factual, and let's not stay with words. The cases in which we have serious doubts should be assessed with maximum responsibility and respect to the rights of individual and willingness to look for the truth. Thank you very much for your attention.
Nyní předám slovo.
And now I'd like to hand over to the John Bock, founder of the Šalamoun Spolek.
Dobrý den.
Good morning. First of all, my thanks go to Mr. Peričevič, the chair of the Šalamoun Spolek, for moving our activities on a higher level. And I would like to thank the Parliament of the Czech Republic, the Chamber of Deputies of the Parliament, that Šalamoun has the opportunity to co-organize similar events on its territory that focus on the problem of breach of not only civil rights but also human rights by this state, by the agencies of this state. We are talking about criminal proceedings. We only focus on criminal proceedings of our legislation. Šalamoun was established back in 1994. And it was the initiative of the writer Lenka Procházková. It's not me who was the founder. We were co-founders with Ms. Procházková. Whatever she's doing today, we must not forget that she was the one who, based on her life experience, she was a dissident as well as I. We understood after November 1989 that we were naive. We were led to believe that the institutions that guarantee civil rights and public order will function smoothly and seamlessly. I am glad and happy that we have founded Šalamoun. We are volunteers. The members are not paid for their work. This must be emphasized. The voluntary activity means that nobody tells us what to do, and that we have to be thankful for having this opportunity to organize this event in the parliament. We are not grateful and thankful. It is obvious. Šalamoun Spolek is not a political association. Of course, our activity has got political impact, but we are unpolitical, and we want that this country has respect vis-à-vis the rights of its citizens. And it's not happening. The judiciary is failing, the law enforcement agencies are failing, and that's why I will always defend the position of the President of the Republic, who can intervene if the society cannot mitigate. Why have I become the President can pardon or give mercy? Why Šalamoun? I am a fan of Earl Stanley Gardner, a lawyer who wrote wonderful books, and Perry Mason was his main character. So it's not a philosophy or my parents. They influenced me, of course, but in the field of law, it was Perry Mason who defended the victims. It's been 80 years ago that Perry Mason founded an organization, the Court of Last Resort. So we need many Perry Masons here and many last resort instances. Thank you very much for your attention.
Tak teď budete mít
Okay, so now we will show you a video from the US. Is that right? V průběhu posledních 3 desetiletí
years ago yesterday, I was sentenced to death for a crime I didn't commit.
You were wrongly imprisoned and you've lost your life. It's the only one you're going to have.
Las condenas cerradas son un problema a nivel mundial. Hay personas inocentes condenadas, lamentablemente, en todo el mundo.
Through the work of the projects in Latin America, they freed 35 innocent people from prison.
Want dit kan en mag dus niet gebeuren.
There's an entire network of innocence projects, just like us in the United States, all around the globe.
Our project in the Netherlands was able to exonerate in the last 15 years 7 convicted persons, which served in total more than 40 years wrong imprisonment.
I know what it is to be behind bars for the crime we did not commit.
Rechterlijke dwalingen komen overal ter wereld voor. En we zien ook dat er telkens dezelfde onderliggende factoren een rol spelen. Dus heel vaak gaat het om valse bekentenissen, ooggetuigenverklaringen. En dat is eigenlijk iets heel universeels. Dus dat zien we in de Amerikaanse data. We zien het nu dus ook in Europese data. En ik denk dus ook dat we daar iets aan moeten doen met z'n allen.
Es ist immens schwer, eine Wiederaufnahme erfolgreich zu bestreiten, allein aufgrund der doch so erheblichen Konsequenzen, die ein Fehlurteil für den oder die Betroffenen mit sich bringt.
Ja, ich bin erleichtert, dass endlich mal die Wahrheit ans Licht gekommen ist.
Ich freue mich auf Neuanfang, dass ich die Freiheit schnuppern kann.
台湾冤狱平反协会自2012年成立。
我不做呀。
蔡老七，无罪！蔡老七，无罪！蔡老七，无罪
！2012年至今，台湾冤狱平反协会已经成功的平反了14起冤错案。
无的人被判有罪，无的人被判有罪，没有人是自由人，没有人是自由人。
It is an international issue. Awful convictions are basically the same in every angle of the world.
冤罪は世界共通の問題です。
Keiko Aoki has been fighting to clear her name for more than 20 years.
Innocence Movement är nu global och vi är en del av den. Den finns överallt eftersom problemet finns överallt. Being in prison, you don't have possibilities. It's impossible for you to reach out. The only persons you are allowed to have contacts with is your lawyer and the family members. Esa Deitinen, he was convicted for murder that he did not commit based on an erroneous autopsy report and a lying witness. It was later proved that the person who had died natural causes, so it wasn't a crime at all. During his time in prison, Esa was denied to give his mother a last call before she died. She died believing that her only son didn't care about her. He was released 2018. First thing Esa did was to go to his mother's grave, bringing her flowers and asking her to forgive him that he wasn't able to say goodbye.
Io al momento dell'arresto nel 96 avevo 2 figli, uno di 45 giorni e uno di 1 anno e mezzo. Non si crea soltanto sofferenza alla persona che è stata condannata e che si trova in carcere da innocente, ma si crea sofferenza, dolore, un trauma ai figli e tutta la famiglia, madre, padre, moglie, e questo non dovrebbe accadere.
Wrongful convictions are caused by human factors. And humans are the same everywhere. Every system, regardless of the exact procedures, uses the same types of evidence. Forensics, eyewitness identification, interrogations to get confessions. Eyewitnesses are mistaken for the same reasons, whether they see a crime in Shanghai or they see a crime in Norway.
You're not alone. You're not alone. It's a global issue. For example, Mr. Necesani, convicted of a murder, the basic evidence was a recognition. The police officer came to the victim, took out the photo album and started showing the photos. Do you see him here? No. Do you see him here? No. He started pointing. I ask you again, do you see him here? Still pointing towards the paper. She pointed at his picture. And that was the basis for his conviction.
Oriktiga domfällelser borde inte förekomma, men eftersom de förekommer så bör samhället i stort bidra till att lösa dem.
Natomiast jeżeli chodzi o prawo międzynarodowe, to istnieje luka. Istnieje luka w prawie międzynarodowym, jeżeli chodzi o właśnie problem niesłusznych skazań.
As we've become this global community, one of the things we've realized is that international law really needs to step up and fill what we call the innocence gap.
Human rights law is incredibly comprehensive. A lot of thought has been put into it. This seems like the kind of gap that was really unintentional, so closely related to existing rights that it seemed like it should have been there all along.
The need for an international human right to prove your innocence post-conviction, and most importantly, to have a viable process in place to do that.
We think there is a role for international human rights law in particular to bolster this innocence movement.
If we want to really step up the innocence movement across the globe, the fastest way to do that and the fairest way to do that is through convincing the UN that they need to start speaking on these issues.
Governments, even if on other topics they're somewhat resistant, this tends to be an area where they're at least open to having a conversation. The idea would be to try to bring the two communities together and come up with a path forward that allows us to identify what should be the next steps.
Justin Brooks of the California Innocence Project and I were both invited to participate by Zoom on a United Nations panel about wrongful convictions. This was followed up by a conference in Switzerland. We've had the attention of the United Nations, the opportunity over 2 days to speak with special rapporteurs, members of the Human Rights Committee, members of the Human Rights Council, key people who we've been attempting to present our case to over the past couple years. All these efforts of trying to get the ear of the UN have started paying off. We've had some fruits of that in the past year. In 2023, we had a decision from the United Nations Human Rights Committee. A person who had significant evidence of innocence in prison in Kazakhstan filed a complaint with the United Nations against Kazakhstan because Kazakhstan refused to look at the new evidence, evaluate it, and exonerate him and free him. And the Human Rights Committee issued a decision, just like a court might here in the United States, that said, this is a human right. It's part of the right to a fair trial. Well, here we have a UN, United Nations body, the Human Rights Committee, for the first time recognizing the right to exoneration through new evidence of innocence as a universal human right. The UN has expressly stated that there's a right to DNA testing for post-conviction, and there's a right to present evidence in order to prove innocence. That was a big breakthrough.
תנועת החפות והמאבק לחשיפה של הרשעות שווא הוא מאבק גלובלי. אנחנו חלק מתנועה גלובלית.
If the United Nations starts speaking in terms of the right for someone in prison who claims they're innocent to have DNA testing done, the right to come back to court and have your conviction overturned when there's new evidence of innocence, right to compensation after exoneration. When the UN starts speaking in terms of these things, they become recognized and adopted as universal human rights. There are people in prison around the world that had no relief before that can now either go to their domestic courts and point to the UN statements and say, this is part of international law. You have to give me the right to freedom.
Las condenas erróneas no están solo en España, sino que están en todo el mundo. Ven y únete al movimiento Innocence.
L'erreur judiciaire est un problème qui nous concerne tous, dans tous les pays, y compris en Europe, et il est temps qu'un droit fondamental, garanti sur le plan international, permette de meilleurs mécanismes pour faire valoir les demandes en révision.
We realize that this is a long battle. It is something we have to do, though.
Tak přiznám se, že asi těžko.
I admit that it is hard to keep emotions at bay when seeing this video. But before I will give the floor to Assistant Professor Koudelka, and he's going to approach the microphone, I would like to remind you that in criminal law, and based on what we saw, this happens all over the world, and under all circumstances and in all cases, we always must honor the presumption of innocence. That's a fact. Cases vary, but principles are the same. And this video and many presentations that we will listen to today are evidence why we need to stick to the presumption of evidence under all circumstances. Assistant Professor, you have the floor. Thank you for inviting me to this event. I would like to apologize for the Minister of Justice absence. He is at the government, but he will come later. When I was asked to come here, I wasn't sure about the topic of my presentation. But I will talk about what caused quite a storm among lawyers. But I will tell you about the possibility of changing changing judges in criminal and civil cases. Sometimes when the appellate court is not happy with the decisions of the lower court, the judges at higher courts compared to judges at lower courts have higher salaries, higher social status, less workload, and more power. However, none of this says anything about whether in their decisions that deviate from those of the trial court they are correct. Nor can it be said that higher courts have better judges, whether in legal or general human terms. For the judiciary, what applies to human society in general also applies, including Murphy's laws, one of which states that an employee is promoted until they reach a level at which they are no longer competent, yet they nevertheless remain in the position. During the monarchy, a criminal procedure code was adopted which introduced lay juries for more serious crimes, with a panel of 3 judges presiding over the main hearing. 12 jurors decided on guilt and aggravating circumstances by a 2/3 majority vote. If this majority was not reached, the opposite outcome applied. Their verdict of not guilty could not be overturned to the detriment of the accused by anyone. A jury verdict of guilt could be overturned in favor of the accused by a unanimous decision of the judicial panel ordering that the case be submitted to a new jury. An appeal could be directed against the verdict on punishment and private claims, but not against the answers of the jury to the questions posed. So, presumption of innocence was honored, and the principle of lawful judge was respected. The possibility of changing court jurisdiction by a higher court in order to enforce a change in the decision of a lower court was one of the measures of the communist reform of the judiciary after February 1948. The February coup led to the communist takeover of power in central state bodies, with the principle of centralism applied in the management of subordinate entities. They called it democratic centralism, but it wasn't democratic at all. A lower authority was obliged to respect and implement the decisions of a higher one. Within criminal justice, this centralizing approach was codified by the Act on Popularization of the Judiciary of 1948. The Supreme Court was authorized within the framework of a complaint for violation of law to assign a case to another court. Subsequently, in 1950, the essentially still First Republic Czechoslovak Supreme Court in Brno was abolished, although supplemented by judges selected by the communist regime from the people, and a new one was created in Prague. In 1956, the Criminal Procedure Code allowed that the powers previously held by the Supreme Court could be exercised by every regional appellate court. That court could, within an appeal, return the case to the trial court and order that it be heard by a different composition of the court or even by a different trial district court, without being limited by any specific reasons, and its opinion was binding on the trial court. This regulation was taken over by the Criminal Procedure Code of 1961 and remains in force to this day. This relic of communist law interferes with the constitutional right to the lawful judge, enshrined at the constitutional level in the Charter of Fundamental Rights and Freedoms. Let us consider an example in which a trial court, first instance, appellate court, second instance, and Supreme Court, third instance, are successively involved in decision-making. Each decides in three-member panels. The trial and appellate courts unanimously acquit the accused. At the Supreme Court, however, the vote is 1-2, with 2 judges believing that the accused should be convicted. Out of a total of 9 judges, across all instances, 2 judges would enforce a conviction against 7, because they have greater power. The opinion of the previous 6 judges from the lower instances is considered worthless. The principle in dubio pro reo suffers. As for case law, it varies. Let me give you an example of a Prague High Court which enforced a conviction for attempted murder in the case of Robert Temple, in spite of being acquitted 4 times by a regional court in Plzeň. The High Court even ordered a change of judicial panel in Plzeň, and when that panel again acquitted him repeatedly, it ordered a change of venue from Plzeň to Prague. In Prague, they decided to go with the opinion of the higher court. 20 years later, the European Court of Human Rights ruled that the Czech Republic violated the Convention for the Protection of Human Rights and Fundamental Freedoms. The Czech Republic paid 12 million crowns as compensation. Temple was imprisoned for 20 years. Similarly, the Prague High Court enforced a conviction for attempted murder in the case of Lukáš Nečesaný, again even by changing the panel in a regional court in Hradec Králové. There, the Constitutional Court intervened and made it impossible. They intervened in even before a final decision had been issued, because to change the composition of the panel was regarded as quite illegal, as a violation of constitutionality, and they immediately revoked it. Right to a lawful judge is a very important one. The Constitutional Court says that the constitutional principle of the lawful judge cannot be circumvented regardless of the reasons. Not only historical experience, but also experience from the recent period of the totalitarian regime convincingly shows how dangerous for individuals and harmful society it is in the administration of justice to appoint court and judges according to purposive criteria in selection. The principle of at least two instances in criminal justice is one of the instruments within European law, but it is sometimes violated if the trial court must go with the decision of the higher court. That is the basic contradiction to how this is understood by European civilization. It is always better to set free several culprits than to give a prison sentence to an innocent person. Therefore, we need to safeguard the presumption of innocence. It is quite interesting that the European Court of Justice of the EU also provided its opinion in response to the first instance Municipal Court Bratislava, and the Court of Justice says Article 3 should be read in conjunction with the principle of primacy of EU law, must be interpreted as meaning that a court of first instance is required to disapply the opinions of an appellate court which annulled a decision to discontinue criminal proceedings and remitted the case to that court of first instance where those opinions are incompatible with the presumption of innocence, even if national law requires the court of first instance to follow those opinions. Among us, there is also our honorable colleague, Professor Fennig. I will discuss the findings of his constitutional court, the decisions which have somewhat limited the higher courts in this practice, but allowed them to do it in the case that the appellate court takes evidence. But I argue that if we look at the law, even the communist legal order only speaks about the binding nature of legal opinions, not factual statements. That means that the appellate court may decide whether a piece of evidence was lawful or unlawful. That is legal opinion, but not the factual consequence of that evidence, like if the accused was at the place where the crime took place. Trial judges don't like this. They have been complaining about the appellate courts, but we know the well-known published statement of Judge Jan Schott, who said, "We remain convinced that the accused should not have been convicted, but we still need to must be done." A judge of the district court in Teplice, Miroslav Čapek, stated directly that such a judgment is in internal conflict with the judicial oath. The Ministry of Justice is preparing an amendment of the criminal order where we want to deal with this issue. In my opinion, it is a violation of the principle of two-instance proceedings and of free evaluation of evidence by the court if a higher court, in the context of remitting a case to a lower court, effectively enforces a different evaluation of evidence which it did not itself take. Nor can it be tolerated that a higher court enforces a finding of guilt upon a trial court, although it does not itself have such authority. It is a belated response of the rule of law state, but nevertheless a necessary one, if the state is only now, through amendment of the Criminal Procedure Code, dealing with the essence of the totalitarian legacy in criminal justice. With a certain acceptance of the binding nature of appellate court opinions, two-instance proceedings can be materially preserved in such a way that if the appellate court binds the trial court as to how it should decide the case, a different panel of the appellate court would decide on the appeal. Similarly to proceedings on reopening of cases or within the public prosecution service. So the judges would not again decide about their own judgment. Presumption of innocence must not be perceived as a piece, as something that is contained in the textbooks and Charter of Human Rights and Liberties, but something that exists also in practice.
Děkuji za slovo panu.
Thank you very much, Deputy Minister. And now I will hand over to our foreign guest, Professor Brandon L. Garrett, who represents the Innocence Project, and he will talk about DNA as an evidence. And I would like to mention that there is a headset on your table, so you can use interpretation.
Tím, než pan profesor začne mluvit, tak se
And before professor starts, I have to apologize because I have to attend the meeting of the chamber. So I will hand over to Mr. Mach.
Okay, it's okay. Okay. So I'm here to talk about a large body of research, interdisciplinary research on wrongful convictions, and also international work that you got a taste of from the video concerning the right to claim innocence under human rights law. My colleague Larry Helfer, who you saw in the video, is a member of the Human Rights Commission of the United Nations. He and I and a third colleague have been writing for several years about the ways in which a right to claim innocence is grounded in existing human rights law, including the right to a fair trial, the presumption of innocence, the right to a remedy, and the right to an appeal.
I'm so sorry. Tak pro všechny, kteří slyší angličtinu.
So for everyone who's hearing English in their headset, on your right-hand side there is an arrow and you can choose that you want to listen Czech. So I hope it'll work.
Sorry for introducing. You need to push the. I'm so sorry. Please dear Professor,
Yeah, oh.
I think it's
Okay.
red light. It's correct.
Oh, red light is correct? Okay. The fundamental grounding of all rights of criminal defendants in the world is the right to a fair trial, or due process as we call it in the United States. My most recent book is called Defending Due Process and presents a body of scientific research on how people evaluate fairness issues in the criminal system. In the book, I talk about threats to due process, both in terms of social awareness and public opinion, the judiciary, and also new technology. To provide just one example, many forms of artificial intelligence and new technology cannot provide people with a fair trial or due process because there's no information about how they work. They are a black box system. I talk in the book about the case of a man named Francisco Arteaga, who was arrested in New Jersey based purely on a match from a facial recognition system that was used on a video from a convenience store that was robbed. Eventually, the trial court and then the appellate courts ruled that he had a due process or a fair trial right to information about how that facial recognition system worked. But during that time, he was held in pretrial detention for 2 years and ultimately pleaded guilty, even though he won on the fair trial issue in court, so that he could be released and see his family again. But fundamentally, the police and the prosecutors could not explain to the court what information about the face from the video was used to make a connection with his face. The system was a black box. They had no information about how it worked. The same fairness issues, however, can occur with more traditional types of evidence as well. Traditional identifications by an eyewitness, traditional confessions during police interrogations, and traditional forensic evidence. And I'll talk a little bit about that work as well. The wonderful remarks just before mine discussed this principle that in all legal systems, we have a presumption of innocence. There's a famous expression of this by the English jurist, Sir William Blackstone, that it's better that 10 guilty persons escape than 1 innocent suffer. I talk in my due process book, though, about a large body of experimental work I've been doing with a psychologist colleague, asking people this question: which error do you think is more important or more harmful to society? First, convicting an innocent person. Second, acquitting a guilty person. Or third, they're both equally serious. And what we find, and this is consistent with surveys done in other countries, is that the vast majority of people think that these two types of errors are equally serious. When we survey lawyers, lawyers tend to think, because we're brought up in the legal system, we believe in the Blackstone's principle. We believe that convicting the innocent is the worst thing that can happen in our courts. Most people don't view it that way. Most people care equally about public safety and fairness. They are deeply committed to fairness, but they also care about public safety. And we find that this is true across age groups, sex, race, political affiliation in the United States, liberal, conservative. There are some very conservative people who only care about not freeing guilty people, but most people care equally about these errors. And these aren't just abstract preferences, but in these experiments, we're asking people to say how they would vote as jurors in different trial scenarios, how they weigh the evidence, how much strength they think the evidence has, corresponds with their error aversions, with their preferences around these types of errors. So we find that these are deep-seated attitudes. There actually was recently a study done in the US, building on our research, surveying judges and prosecutors, and they found the same type of thing. So it's a very understandable, deep-seated attitude that people do not start with the fundamental premise of our legal system, which is guilty until proven innocent and a beyond a reasonable doubt standard of proof. Most people view these things as equal, and we have to explain to them that there's an important reason, even if you care equally about public safety. In the instance of an innocent person being wrongly convicted, both bad things happen. If the crime did in fact happen, and sometimes people are exonerated when no crime occurred, but if the crime in fact happened, a guilty person is wrongly convicted, and the guilty person is out there unpunished. Both errors happen at the same time, which makes that situation especially serious, which explains in part why we have a presumption of innocence across the world. But many people don't realize that both of those things happen at the same time. Both errors happen when an innocent person is wrongly convicted. My first book, which is an old book at this point, examined the first 250 DNA exonerations in the United States. And part of the challenge of that research was that I went back and obtained the original trial records from all the criminal trials that led to those wrongful convictions. I mentioned earlier this morning that it typically takes about 15 years in the United States, even with the benefit of DNA testing, to obtain an exoneration in these types of cases. There are also many thousands of exonerations, over 3,000 cases, where people were exonerated without DNA testing. I've recently updated this database. It can be viewed online. There have now been 455 DNA exonerations in the United States. We think we will reach 500 in the next year or so. What makes these cases particularly interesting is that it's this outside technology that was used to free people. And so there can be very little dispute that the new evidence paints the old evidence in a fundamentally different light. What I think also is useful to look at when you think about a system in which it's very challenging to overturn convictions, like in Czechia, and like in most places in the world. What I wanted to see was what happened in these people's cases before they got DNA testing. What happened when they brought ordinary criminal appeals, ordinary post-conviction proceedings? And what I found is that along the way, until they were able to get DNA testing, these people brought every kind of appeal and they lost. The people who were convicted based on eyewitnesses, who we now know had altered memory and made mistakes, most of them didn't even try to challenge that evidence, but when they did, they lost. The people who falsely confessed, most of them did try to challenge that evidence, they lost. People who are convicted based on jailhouse informants or other types of informant testimony. We now know that those informants lied, but when they tried to challenge it during their regular appeals, they lost. In a more recent study, I looked at a situation which is a fair trial issue everywhere in the world, which is what happens when there's evidence of innocence that the police and prosecution have, but they don't share it with the defense. In the United States, there's a constitutional claim on that topic that comes from an old Supreme Court case called Brady versus Maryland. A co-author and I built a database of rulings examining those claims of prosecutorial and police misconduct. Going back 5 years, we're now building a 10-year database. What we found was that people won on those claims about 10% of the time, which is not bad considering how difficult it is to show that evidence was concealed at the time of trial. But what was especially interesting was that in many of the cases in which people lost, courts agreed that evidence of innocence was concealed, that it was concealed by police and prosecutors, that it was evidence of innocence, but they said that the evidence wouldn't be material enough to have changed the outcome at trial. Often when they said that, they actually engaged in reasoning which is not permitted in the United States or in many countries. Often what they said was that the person basically seemed like they were probably guilty, or that there was other evidence in the case which seemed strong enough. The correct inquiry is, was this evidence material, this evidence that was suppressed? But many judges in the United States, I think, fall victim to a kind of a cognitive bias, where they care about public safety and they care about fairness. They just focus on public safety. They focused on the other evidence in the case, and they say that maybe the jury could have convicted based on that. That's not the reasoning that is permitted by the US Supreme Court, but it's understandable that judges around the world, they just tend to follow the sort of path of confirmation bias. They know that the person was already convicted, and they want to validate that conviction, and they don't examine the appropriate question, which is, was the evidence that was suppressed or concealed powerful enough to have reasonably affected the outcome at trial? And so we've documented these errors in the United States large scale in cases where it shouldn't have just been 10% of these people who had their convictions overturned. It should have been more like 30 or 40%. This database is also available online. I also wanted to highlight how one of the most common causes for wrongful convictions around the world is errors in eyewitness memory. Eyewitness memory is an issue even if modern technology like facial recognition is used, because typically facial recognition will help to identify a suspect, but the picture of that person's face is also shown to the eyewitness. There is an important report of the National Academy of Sciences in the United States that breaks down the scientific research. And now there have been many decades of scientific research by psychologists and neuroscientists, also contributions by statisticians, showing how eyewitness memory predictably fails at very high rates. And in fact, new search technology can increase the chances of error because the larger the databases, people think that database search improves evidence, but with larger databases, it's much easier to find photographs that look a lot like the suspect, but are of an innocent person's face. You're going to have many more near matches when you have a larger database. That's a problem with fingerprint databases, and it's a problem with face databases. It's very likely that if you have a database with millions of photos, you can find a picture that looks just like my face, or just like any of our faces. But one of the most fundamental concerns anytime that eyewitness procedures are conducted by police is that you don't want to happen what we saw in the presentation about one of the cases in Czechia, where the police officer is providing suggestions to the eyewitness. Eyewitnesses are very vulnerable to suggestion, and it can change their memory. There have been really remarkable cases in the United States where eyewitnesses have since spoken about how they know because of DNA testing that they identified an innocent person. And they feel like they were doubly victimized because they were victimized by the true culprit and they were victimized by police who convinced them that a different person committed the crime. But some of them even describe how their memory was permanently altered. They still see the face of a person who they know is innocent in their head when they think about the crime. And they know with the benefit of DNA testing that it's the wrong face. But memory our visual memory is very fragile. And that's been the lesson of decades of psychological and neuroscientific research. Unfortunately, and I've done a lot of research with psychologists on how fact finders view eyewitness evidence. Fact finders, whether it's a judge or jurors, they think it's really powerful if an eyewitness is confident, if they seem sure. The problem is that when police make suggestions to an eyewitness, they increase the confidence of that person, even if they are wrong. That was the pattern that I saw across these cases of DNA exonerations in the United States. Almost without exception, these eyewitnesses who we now know were wrong, not on purpose, but because their memory had been altered, almost without exception, they were 100% confident. Some of them even testified at trial. I'm 200% confident. I'm 110% confident. I'm absolutely sure. And we now know that they were wrong. Here's an example of a suggestive unfair lineup, just as a joke. We see the same problem of inflated testimony in court in cases of false confessions. In the United States, almost without exception, the false confessions in DNA exoneration cases were said to have included details that only the true, usually the murderer, could have known. And so the jury had no problem convicting these people. Judges had no problem agreeing that this person was obviously guilty because these confession statements included these details that only the law enforcement investigators knew. This was an example of a confession in New York State where the person had described things like the victim's clothing, the location of the murder, that were not made public by the police. We now know that the police officers in that case told him those details to make the statement plausible, to make the statement realistic, to make it believable. They comforted him and they gradually fed him the details of the crime so that his videotaped confession statement would seem not just heartfelt, but accurate. With the benefit of DNA testing, we know that in over 100 cases, police did that. They contaminated interrogations by feeding details. But if you don't have a video of the entire interrogation, there's no way to know that police engaged in those tactics unless you have something like a DNA test. And so in this case, there was a video, but only of the statement that he made after hours of preparation with law enforcement. And we have examples of false confessions like this all around the world, including in some of the cases highlighted in that video from Japan. All across the world, contamination of confessions is a serious problem. There's a large body of scientific research about the contributing factors as well. There's a very good review paper by the American Psychology Law Association, some of the top psychologists in the world, who have described the principles that lead predictably to false confessions. Unfortunately, while we rely on scientific evidence in criminal cases, DNA testing has been used to free hundreds of innocent people in the United States and to a lesser extent around the world, like I described. Traditional forensics and modern forensics like DNA can lead to wrongful convictions when they are misused, and they often are, because in general, crime laboratories are not regulated according to the scientific standards of any basic clinical laboratory in a hospital. When you get a COVID test or a test for strep throat or a cancer screening, those tests are regulated with careful proficiency evaluations of the people running the tests and laboratory standards. But around the world, crime laboratories are typically not subject to those standards because they grew out of policing. There have been major reports in the United States and in several other countries that came out of inquiries where wrongful convictions resulted from misuse of forensic evidence. I wrote a book called Autopsy of a Crime Lab, describing the different ways that forensics can contribute to errors. I was part of this group called CSAFE, which came out of decades of concern in the United States that forensic methods lacked any statistical underpinnings. In general, in courtrooms across the world, you have analysts like fingerprint analysts, firearms analysts. Basically, anyone who's not doing DNA or drug testing will testify about forensics, and they'll just say that it's a match. That's not scientific. Any measurement in science involves statistical uncertainty. A statistical result is presented. But traditionally in forensics, they would just say it's a match. It's a match to the teeth, it's a match to the gun, it's a match to the fingerprint. And we see that in courtrooms across the United States now too. So this group called CSAFE was developed to bring statisticians into forensic science. All of this came out of a series of scientific commissions in the United States. The National Academy of Sciences issued a report back in 2009 saying that traditional forensics outside of DNA have no statistics. How can that be? How could we not know what the error rates are for traditional forensics? This presentation included an exoneree named Keith Harward, who has spoken at Duke since he lives in North Carolina, where I teach. He was identified based on a bite mark comparison. The statistics that were offered at his trial was that it was very, 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 very likely that the teeth came from his mouth. And it turned out to be false. Actually, years later, DNA testing showed that who the correct culprit was. But very, very, very likely is not statistical, and it's not based on research. In fact, when studies have more recently been done, they have found that these forensic dentists are no better than chance at telling whether a mark came from a human bite as opposed to insect bites. They can't even tell reliably whether it was a human bite or not, much less whose bite it was. This presentation was at the White House when there was a presidential commission that did follow-up work after the 2009 National Scientific Report by the National Academy of Sciences, finding that in 10 years, still very little had changed in the United States. And there was a need for basic assessment of what the reliability of these different forensic methods was. At that time, in the world, there had only been 2 studies evaluating the reliability of fingerprint examiners. Since then, there has been one additional study of palm print comparison. But for something that's used around the world as frequently as fingerprint comparisons. The idea that no scientists had ever studied the error rates, and that at that point only 2 studies had been done, but one of them was 30 analysts at the Miami Police Department. These are not real scientific studies. Again, we would never take a drug. We would never rely on a test for the flu if it had only been tested on 30 people, and 30 police officers at that. Again, I've mentioned how modern databases can raise additional challenges because they're going to have more evidence that looks like other evidence, more faces that look like each other. I'm not sure how much time I have left. Maybe I should.
Yes, we're running out, unfortunately.
I will skip over this next section on concerns with black box AI. I do want to mention that in the United States, there has been a real movement to improve the scientific standards in criminal cases. Our federal rules of evidence were amended specifically because of the concern that in criminal cases, judges had too often been neglecting the basic rules for scientific scrutiny of scientific expert testimony. So there is a principle in the United States that a judge is supposed to carefully be scrutinizing whether scientific testimony is reliable enough. And the concern was that judges had not actually been properly following that standard in criminal cases, and the rules of evidence were actually amended for the first time in 20 years, specifically based on that concern. Finally, I just want to highlight, and you've seen a film about this already, that there's work being done around the world to explain why the existing fair trial rights, rights to an appeal, rights to a remedy, all relate to the important right to bring up new evidence of innocence even after a conviction is final. It's obviously not easy anywhere in the world to overturn final convictions. But in principle, if the evidence is powerful, it shouldn't matter when it comes to light. And that's been one of the lessons of DNA exonerations. Often, in the United States, it has taken 15 years. Sometimes it takes many years to even locate biological evidence that can be tested. But that evidence is more reliable, typically, than the eyewitness or the confession evidence that contributed to the person's conviction in the first instance. Like the film mentioned, there are a series of rulings, including from the UN Human Rights Committee, that have recognized this as a derivative right connected to the right to a fair trial, connected to the right to an appeal, also connected to the right to life in death penalty cases in countries that have the death penalty. There are a series of these different opinions that have recognized this right. There's a quite significant body of law at this point from the Human Rights Committee. Some of these rulings were mentioned in the movie already. Anyway, thank you again. I'm sorry if I'm over time. I should have mentioned that in my early career as a lawyer, I represented people who had been exonerated by DNA testing in the United States. There I am with 2 members of the Exonerated 5, a very high-profile case in New York City. It can take many years for these people to be exonerated. It can take even more years for them to obtain adequate compensation. That is one difference as well in the United States. For example, the 2 individuals here, each member of the Central Park 5 case received many millions of dollars of compensation. Because we have a jury trial system, so you can ask jurors, even if people may believe that public safety and fairness are sort of equally valid, once people find out that someone had been wrongly convicted, and you ask them, how many years would you pay to not be in prison for something that you didn't do? Typically, jurors in the United States have said at least $1 million a year, because it's almost unimaginable what that would be like. And in a case like this, many of these people are young. Most people, when they're convicted of violent crimes, are young, 18 to 25 years old. Losing the best years of your life, when that goes to a jury that has no cap on compensation, they typically award many millions of dollars in damages, which has also changed the public debate in the United States as well. Anyway, thank you again for this opportunity to present, and I hope to meet some of you during the events today. Thank you to all the organizers of the symposium.
Thank you very much, Mr. Garrett.
Now I would like to give the floor to Mr. Václav Peričevič. He is the chairman of Šalamoun Spolek. He will speak about retrial as the last safeguard against a miscarriage of justice.
Tak, dobrý den, já vás tady
Good morning, welcome everyone. We're happy that so many of you arrived. We did not expect this. We were really taken aback by how many of you showed interest. We had to switch off the registration forms 2 weeks ago. This testifies to the importance of miscarriages of justice as a topic. It is important for the Czech public. The colleagues with their video from the Innocence Project highlighted that miscarriages of justice exist all over the world. We have wrongly convicted people all over the world. There is no country where this never happens, except for one country, and that is the Czech Republic. This never happens here. I will speak about retrial. Retrial is the last safeguard against miscarriage of justice when people are wrongfully convicted. The section 278 says the reopening of proceedings that concluded with a final judgment or a penal order shall be permitted if facts or evidence previously unknown to the court come to light, which either on their own or in conjunction with facts and evidence known previously could justify a different decision regarding guilt, and so on. This retrial should not be a matter of deadlines like appeal, extraordinary appeal, constitutional complaint. The convicted person may file it in the course of serving a prison sentence when new facts come to surface or scientific evidence like DNA, as we have heard from our friends from Innocence Projects. They managed to free many people who have convicted even to a death penalty when it was shown that the real culprit is someone totally different. We should also say that the section 278 is in fact has been the same since the very beginning of our Czech Criminal Procedure Code from 1961. That's a very old law which has not been recodified, so we really have Criminal Procedure Code from 1961. Spolek Šalamon has been monitoring retrials for a long time. In the last 12 years, we have been collecting statistical data about retrials from regional courts. Retrial at a regional court is the court which decides rules as the first instance primarily on criminal offenses for which the law sets a minimum prison sentence of at least 5 years or an exceptional sentence. So we only monitor the most serious crimes where you can even impose an exceptional sentence, that is prison for life. Since 2012 until 2025, that is 13 years, we have statistical data from the Ministry of Justice. And in the course of this recent period, I'd like to draw your attention to two moments. In 2019, there was one event which was quite unique. When David Schneider, who was convicted, he was put in prison. He found the actual culprit for which he for the crime that he was wrongfully convicted of. We have been saying that we are the only country of Europe where retrial was decided by a judge or a court who decided the case in the first instance. Professor Válková managed to bring through an amendment that in section 30 the judge and the panel must not hear about the retrial that been active in the first instance. Still, in our opinion, this is very wrong. The legislator probably did not consider that there are two parts of the proceedings. Nowadays, if the convicted person files for a retrial, then this is heard by the same court but a different panel or judge. But after that decision is made about the retrial, then the case goes back to the judge or the panel that heard the thing in the first case. So this is quite a nonsense. Unfortunately, the Ministry of Justice really did not think this through. In 2022, we hoped that there would be a correction or a big increase of the number of retrials because a new judge or panel would decide about allowing the retrial, because it is very hard for a judge or a panel to decide that they have been wrong. So we have been really monitoring the decisions. We ask for the wording of the decision, and only to hear that the retrial was to the detriment of the accused, and it was filed by the public prosecutor. So that is another moment. And the last thing I want to speak about is took place in 2025 that only dealt with procedural deficiency of the previous of the plea bargain that was then later revoked. So the judgment was taken aback. And now the most important data in the last 13 years, since 2024, 1,184 motions were filed. These were serious offenses, and no retrial was granted. We have the most perfect justice system in the world, because as we heard in the video, all over the world there are miscarriages of justice in all countries, except for the Czech Republic. It is hard to believe, even from statistical point of view, that out of 1,184 motions, none was granted. We cannot analyze all these 1,184 motions. We don't know them all, but we look at some of them and we monitor it. Be it the case of Kramny, we will hear about it in a while. But for example, there were the problems of scent traces. It was really quite unique when legal professionals, academicians and scientists raised their voices, saying that scent identification that was used as evidence until 2018 was totally wrong. We expected that if all these scientists and legal professionals will raise their voice in this manner, that the courts will take this into consideration. We knew of a Dutch model when where in 2016 in the Netherlands the handlers even agreed on the cans of scent traces. They knew which cans were correct. But this was a standard, so the handler knew which can of scent traces is the correct one. So what was a crime in the Netherlands was a standard procedure here. When this was discovered in the Netherlands, the Dutch judiciary had 3,058 cases reviewed and 15 people were exonerated as a consequence. What happened in the Czech Republic? Nothing. There were some retrials took place. We were personally present at the sessions, be it the cases of Balak, Lukáš Dobeš, Radim Žandra, and other people. In none of the cases, in spite of the professional public saying that these scent traces are totally wrong evidence, which should be inadmissible, nothing helped the falsely convicted persons. Our colleague even made a documentary film about this, which was successful all over the world. In Italy, it won a prize. And in the documentary film, we hear the president of the Judicial Union, Dr. Vávra, who says how many judgments are proclaimed in the Czech Republic. Czech courts issue a... I've read somewhere that the most meticulous car, which is allegedly Toyota, produces about 40%. So are we better or worse than Toyota? Of course, we are better than Toyota because we are the best ones in the world. We have no faulty cars and we have no faulty judgments, because the basic principle of the rule of law is that it is able to admit that it committed a mistake. But this has not happened in the Czech Republic as yet, and the statistics show this. And we do not remember in the history of our Šalamoun Spolek when a retrial would be successful. Our justice system is free from mistakes and errors. No one believes this. We don't believe it. Our foreign friends do not believe it, but the figures speak for themselves. So what should we do in future? Is the legislator serious about this whole section 217? It really should be probably done away with, because if you don't allow for a single retrial in the last 13 years, this is a very convincing information with a clear information value. And you will hear in the further presentation that the principle, the reason why retrials are not allowed, is that we would lack new evidence or they would be insufficient. The system is just defending itself. It is unwilling to admit that the factual narrative was completely wrong, even if the evidence points to it. But the justice system does not have a corrective mechanism to admit its own mistakes, and this is the biggest failure in the state with a rule of law. Thank you for attention.
Thank you. And I would like to hand over to Mrs. Jana Barvíková, who will present the Kramny case and new facts. Hello, ladies and gentlemen. Well, there are no MPs present, so it is up to the guests. And dear guests, I would like to inform you about the Petr Kramny case that is taken as a closed case by the public. His case, in which the Czech judiciary identified a culprit, the courts judged this, and the Czech public could feel a relief. This is dangerous. The deeper you look into the evidence, the less it looks like a story of justice. It reminds of a case in which various versions of the whole event were created, and only then the version of death by electric current evidence was collected. Petr Kramny was sentenced for having killed his wife Monika and daughter Klára by electric current in Hurghada Hotel 6345. Was it proven, or was it accepted as an explanation after previous versions were not proven? Is it a dogma? It has not happened what should happen in a fair trial. Not all real possibilities were examined. Evidence were not looked everywhere. Doubts were not examined. Something else happened. Everything that disturbed the version on electric current has been put on the margin, and everything that supported the electric current death was taken as a clear evidence. The first and last person who saw the stomachs, the first person was Dr. Naji, Egyptian forensic doctor who did the first autopsy and was the first one and the last one who saw the inner organs, in particular the stomachs of Monica and Clara Kramny. These samples, necrological material, were not sent to the examination in the Czech Republic is questionable, and it raises many doubts. Did the court want to examine the stomachs and find out what was the real reason of the death of Monica and Clara Kramny? And not only the samples of stomachs were delivered to the Czech Republic, but Dr. Naji was not even interrogated in a way that would correspond to the importance of his conclusion. First doctor, first evidence, strongest evidence was not made, although the defender has always suggested to interrogate Dr. Naji. Failure. In 2025, the defenders of Petr Kramny went to Egypt, and in Hurghada they took 2 hours video recording of Dr. Naji, who carried out the first autopsy of Monica and Clara Kramny, who could describe what he saw on their bodies and on the parts of their bodies that were never sent to the Czech Republic. These are new facts, very serious facts. One of the problems that challenge the idea of fair trial of Petr Kramny. The defender had to go to Egypt and interrogate a doctor. Czech agencies were not interested in such interrogation. Another new fact of the same weight. It was found out that there exist better quality photographs of Monica Kramna before the autopsy in Egypt. Photographs of such quality that they allow the forensic assessment of changes in the area of her neck. So if the electrocution is to be proven, then it is important that these photographs allow the conclusion that on the neck of Monica Kramna there was no such sign found on the neck of Monica Kramna. And then we have to ask, when did this sign appear on Monica Kramna's neck, and why didn't a doctor saw it? Doctor who made the autopsy as the first one. So Dr. James Filkins will tell us more in a video in a while. And we have to ask the post-mortem artifact, did didn't it happen? Key evidence of a murder? The whole construct is based on the idea that the killing by the electric current happened in the room 6345. But the defenders of Dr. Kramny also focused on the location of the crime. The defenders who really managed to visit the room and see how the room looked like, we were told that this room's layout has not changed since the death of Monika and Klára Kramny. So if somebody is to be convicted of a murder by electric current, you have to prove the source, mechanism, and the entry point of the electric current to the body. You have to explain why such mechanism left no technical and biological trace, and you have to prove how do we know that it happened in that very room at that very moment and in the way that is mentioned in the judgment. In this case, the room 6345 has become a place where the electric current version was moved. It has become a room or a scene where the murder was transferred. And 28 years of imprisonment is too much for such a procedure. Radek Matlach and Igor Farkas, two forensic experts who said, we know exactly how Monika, they did not say, says the speaker, that we do not know how Klára and Monika died, that they have a final alternative story. Their conclusion was there are some other possible causes of death than electric current, and in connection with the judgment that allowed some other cause of death led to their prosecution for a false forensic report. If the expert says that there is another possible cause of death than the one accepted by the law enforcement bodies, and the expert is then taken to court, we have to take it as a message and signal for all expert witnesses. If you go against the accepted version, you can be accused. And this is very dangerous for a fair trial. Fair trial is not based on the obedient experts, but on the experts who are not scared and concerned to give their professional expertise, although it might be inconvenient. Proposal for a retrial was lodged, and the general public knows how it was assessed. But before we tell you more, we have to say that it was not only Dr. Matlach and Dr. Farkas's reports were not the only reports. Ivo Steiner, Alexander Vilím, Zdeněk Horák, Zdeněk Kokeš, and Zdeněk Šňupálek also delivered a report. According to the defender's knowledge, these experts have not excluded have excluded categorically that the cause of death was the electric current injury. So the first experts have not excluded other alternatives, and the following experts concluded that the electric current injury probably was not, categorically was not the cause of death. And Steiner, Willim, Horak, Kokes, and Schnupalek were not prosecuted for their report because it would mean to show that the king is naked, that it is a problem, that there are doubts, that somebody says the electric current injury was not proven. It shows that Matlaf and Farkas prosecution was to deter the others, and it shows that in 2022, when the expert opposition against the electric current injury was strong, that's why the experts who have excluded the electric current injury as a cause of death have not been prosecuted. In 2022, something important happened. Docent Pilin was to be interrogated, and the prosecutor demanded that his expert report should not be presented to the court. So he failed. The court accepted the evidence, and it shows a problem of retrials. The defenders did submit conclusions that might have changed the cause of death conclusion. They simply wanted to keep it aside. So what is the core of the problem? Do the Czech criminal proceedings allow new evidence if they go against the subject matter of the conviction? The system must be able to accept that they are not unmistakable and unfailing. The Czech Republic is failing. It is mistakable. It is not. The Czech Republic is not better than Toyota. Or we are not only a decoration of the state of law. Petr Kramný case. We have the testimony of Dr. Nagy. The stomachs of Clara and Monica were not made available to the Czech Republic examination. The quality photographs of Monica Kramný before the Egyptian autopsy were not made available, and James Filkin's statement has not been accepted. So the overall picture really undermines the mechanism of death, which undermines the judgment and the sentence. So já se jmenuji
Greater Chicago, Illinois area. I want to thank Vaclav Paracevic for inviting me to present my opinions in the matter of Petr Kramný at this meeting. Given that I have been allotted only about 10 minutes, I believe that the most useful way for me to present my opinions is by reading my affidavit into the record. I will do that now. I James A. Filkins, MD, JD, first being duly sworn according to law, declare I am a doctor of medicine exclusively specializing in forensic pathology. I have been continuously licensed as a physician in the state of Illinois, USA, since 1993. Over the course of more than 30 years of active practice, I have personally conducted over 10,000 post-mortem examinations, including examinations of including examinations involving electrical injury. A copy of my current curriculum vitae is attached as Exhibit A to this affidavit. In July 2025, Professor Mark Godsey of the University of Cincinnati, Ohio, USA, College of Law, forwarded to me a request for assistance from Spolek Salomon regarding the deaths of Monica Kramny and her daughter Clara. On July 30th, 2013, Monica and Clara Kramny were found dead in room 6343 at the Titanic Palace Hotel in Hurghada, Egypt. The question presented for my review and opinion was whether there was any pathological evidence based on the post-mortem examinations of Monica and Clara Kramny to indicate that the cause of their deaths was electrocution. Accordingly, I have reviewed a variety of materials provided to me by Spolek Salomon. The materials I have reviewed include the reports of the post-mortem examinations of Monica and Clara Kramny, conducted in Egypt and subsequently in the Czech Republic, a video recording of the post-mortem examinations conducted in the Czech Republic, post-mortem photographs of Monica and Clara Kramny taken in Egypt and in the Czech Republic, photomicrographs of tissue samples removed post-mortem, investigative reports, and the reports and statements of other medical experts. Low-voltage electrocutions often, but not invariably, produce characteristic burn marks on the skin. Firm contact of the skin with the source of the electrical current may produce a blister with a pale ring surrounding a central crater. If the source of the electrical current remains active and in contact with the skin for a protracted length of time, then a larger, more severe burn can be produced. If an air gap exists between the skin and the source of the electrical current, a spark burn may occur if the current arcs across the gap. Spark burns appear as small crusted nodules of tissue surrounded by pale areolas. Microscopically, the skin of an electrical burn may show separation and necrosis of the epidermis, as well as bubbling or vacuolation of the epidermis with elongation and streaming of the individual cells of the epidermis and their nuclei. As many as 50% of low-voltage electrocutions, however, leave no burn mark, according to a Miami, Florida study by Dr. Joe Davis and others published in the Journal of Forensic Sciences in 1980. Electrocution is, however, never a diagnosis of exclusion or a default diagnosis. Accordingly, standard forensic practice requires that the investigation of any suspected low-voltage electrocution includes a thorough examination of the scene to identify the source of the electrical injury. The hotel physician at the Titanic Palace Hotel, who first examined the bodies of Monica and Clara Kramny when they were found on July 30th, 2013, estimated that they had been dead approximately 3 hours. Seen photographs of the hotel room in which Ms. Kramny and Clara were found show them each lying in a supine position in separate beds. The position of Clara's right arm suggests that she may have been in rigor mortis at the time the photograph was taken. No signs of decomposition on either body are visible. Dr. Nagy performed the first autopsy, Dr. Nagy performed the first autopsies of Monica and Clara Cramney on July 31st, 2013 in Hurghada, Egypt. Dr. Nagy's examination, as reflected in his postmortem report, found no evidence of any electrical injury or any other signs of violence on the bodies of either Monica or Clara Cramney. Postmortem photographs taken at the autopsies in Egypt of Monica and Clara Cramney show no electrical injuries or any other injuries to the body, apart from a purple bruise on the side of the left thigh of Ms. Cramney and a purple bruise on the left knee of Clara. Investigative reports by Egyptian authorities provide no indication of any power outage, faulty wiring, defective appliances, or other electrical apparatuses in the room that could have caused or indicated electrocution. The bodies of Monica and Clara Cramney were transported back to the Czech Republic on August 8, 2013. On August 9, 2013, Monica and Clara Cramney were autopsied a second time in Ostrava, Czech Republic. A video recording was made of these second autopsies. As shown in the video recording of the autopsies, the bodies of Monica and Clara Cramney were each wrapped in a white fabric shroud. Each body was then wrapped in a plastic tarpaulin, which was firmly secured in place with a white fabric binding that was looped snugly around the body at various locations, including the neck and ankles. When the tarpaulins and shrouds were removed, it was obvious that the bodies had undergone significant decomposition changes in the 9-day interval between the first autopsies on July 31st, 2013, and the second autopsies on August 9th, 2013. On the back of the neck of Monica Cramney, there was a mark, which the pathologist who performed the autopsy interpreted as an electrical burn, leading to the conclusion that Monica and Clara Cramney were electrocuted. No mark is visible in the photographs of the back of Monica Cramney's neck that were taken at the first autopsy in Hurghada, Egypt, nor was such a mark identified by Dr. Nagy or other Egyptian doctors. No mark was identified on the body of Clara Cramney at either the first autopsy in Egypt or the second autopsy in the Czech Republic. A sample of skin from the back of Monica Cramney's neck, as well as sections of cardiac tissue from both Monica and Clara Cramney, were taken for microscopic examination. The mark on the back of Monica Cramney's neck, seen in the video recording in the Czech Republic, can most accurately be described as a discontinuous furrow that is darkened because of decomposition changes and postmortem desiccation. The skin appears torn or lacerated. There is no blistering or burning of the skin, and the margins lack the pale areola that is often seen in electrical burn. As shown in the video recording of the Czech autopsy, Ms. Cramney lay in her coffin in a supine position so that the posterior portions of her body bore her weight. There was sufficient space within the coffin for her body to have shifted somewhat over the course of its journey from Egypt to the Czech Republic. As seen in the video of the Czech autopsy, there are narrow indentations or creases on Ms. Cramney's back and buttocks caused by the weight of her body pressing into the folds of the shroud and plastic tarpaulin against the bottom of the coffin. There are also shallow post-mortem abrasions visible on Ms. Cramney's back. These post-mortem abrasions were caused by a combination of the pressure from her body weight against the shroud, plastic tarpaulin, and bottom of the coffin, and the friction produced by her back rubbing against these surfaces as her body shifted during transport. Neither the indentations nor the abrasions were present in the photographs taken at the Egyptian autopsy. The relevance of these considerations to the question of electrocution is significant because the location of the mark on the back of Ms. Cramney's neck corresponds to the location where the binding was snugly wrapped around the neck. Accordingly, the pressure of Ms. Cramney's body weight against the shroud, plastic tarpaulin, bottom of the coffin, and the binding, as well as any shifting of her body during transport, would also have produced the mark to the skin on the back of her neck found at the Czech autopsy. In my opinion, the mark on the back of Monica Cramney's neck is simply a post-mortem artifact caused by the manner in which the body was shrouded, wrapped in plastic, bound, and positioned in the coffin. It is not an electrical burn. The Czech autopsy report described the histological appearance of the muscle fibers of the heart tissue as consisting of wavy or zigzag fibers, a finding interpreted to be consistent with electrical injury. Wavy or zigzag heart muscle fibers can be seen in deaths from many different causes. It is so commonplace and non-specific a finding as to be of no diagnostic significance at all. The Czech autopsy report also described the histological appearance of the cross-section of skin taken from the back of Ms. Cramney's neck as showing thinning of the epidermis at the central portion of the cross-section, filamentous elongation of nuclei and crowded and pycnotic nuclei in the thinned area, and focal loosening of the connective tissue of the subcutis. These findings were also interpreted as consistent with electrical injury. The histological appearance of the cross-section of skin from the back of the neck shows nothing more than sloughing away of some of the most superficial layers of the epidermis, a finding to be expected given the decomposition changes and the appearance of the mark on the back of the neck. The cross-section of skin lacks the bubbly coagulation necrosis and nuclear streaming often found microscopically in the epidermis in electrical burns. There is no vital reaction. That is, the mark on the back of the neck did not arise while Monica Cramney was alive. The histologic appearance of the cross-section of skin is, in my further opinion, also nothing more than a post-mortem artifact brought about by the decomposition of the body and the post-mortem mark to the back of Ms. Cramney's neck. Accordingly, based on my review of the materials provided to me, as well as my education, training, and experience in forensic pathology, it is my opinion, to a reasonable degree of medical certainty, that the cause of death of Monica and Clara Cramney was not electrocution. A written copy of this affidavit is attached as Exhibit B, and that concludes my reading of the affidavit. Once again, I want to thank Mr. Parachevic for inviting me to present my opinions at this meeting, and I want to thank those of you in attendance for your attention in listening to my presentation. Thank you very much.
Thank you for letting us see the whole recording of the Dr. Filkins' expose. Not that a foreign expert would be more important than a Czech expert, but because he comes from outside, is not part of the Czech judicial history of this case, and he does not have to worry about what whoever said in the year 2012, 13, or 15. Ladies and gentlemen, we are the truth seekers. Let us believe that in case that a new motion for retrial will be filed, that it will be more successful and that the judiciary will take the evidence and evaluate them fairly. Thank you for attention. Thank you, Dr. Barvíková. And we will now view a sample from a new documentary film from a filmmaker of our Spolek Šalamoun, who is the author of this documentary film.
سكيبان هو ما جاش هو الريسبت بتاعه بيسيبه جوه؟ لا موجود. طب ماشي دخلهم يصوروا صورة كده.
There's nobody there.
Ja nie wiem, jak to znaleźłem teraz. Jak są te zasówki? Tady nejsou zasówki.
There are no electrical sockets. You cannot open this. You can go from the side. It's not there. Wait a second. Let me pull it out. I cannot pull it out. Yes, you can pull it. Yes, you can see it quite clearly. Pull it out even more. No, no, really. To kill both of them with electrocution is impossible, and one after another impossible. To kill two persons at the same moment using an extension cord is impossible. You can even say that it's impossible because on one of those persons there are no signs of electrocution, and there's none trace of electrocution on the other one either. The local doctors have not seen it. The first thing they looked at was the neck. They were checking whether they have not been strangled, so they really had to look at the neck and throat in detail. So where is that trace? We highlighted one sign that quite clearly proves electrocution, and in world literature this is the only evidence that says that it can only be seen in electrocution, nothing else. Can you be more specific? Yes, I said this at the during the main trial. Yes, this is the paling of around the trace.
There is one injury in his side, and the other parts of her body is complete.
Okay.
Okay.
You mean completely clean? No.
Clean. No one's is.
No spot. No anything.
Yes. But it is a small injury, as contusion in her side only.
On the leg.
Yeah. But the remaining of her body is completely clean and free from injuries.
And the pathologist from Egypt or the forensic forensic doctor from Egypt. Did you hear it? No. Did you listen to him? No, that would not help us because we sincerely doubt that he is a true expert. Is there any evidence? Yes, he did not make an autopsy at all. If I recall well, when examining the location of the crime, there was a lady who was not a policewoman. There must have been Ramadan at that time, and a male policeman was not allowed to touch female bodies. So the inspection of the bodies on the spot was very strange indeed, according to our criterion.
Is it true? Does the holiday affect workings of the public offices and
all of them work well as any time of the year.
It doesn't affect the examinations, the investigations?
You mean some change in the mind?
For example,
from fasting?
No.
The fasting gives all the body here in Muslim more sharp.
More sharp. Oh, yeah. Okay.
Our fasting in Islam do the brains of all Muslims very sharp. And very alert.
So during Ramadan, it's even better. You are better performance of authority.
No food, no stomach ache, no any problem.
Tak já vám moc
Thank you very much for attention in the course of the morning portion of our seminar. You are all entitled to this book, Crime Without Weapons. You can pick up a copy, you can get it signed by its author next door, and there's also a leaflet there asking you for a small contribution. There is lunch provided also, so if you can please give us a small pecuniary contribution. It will take place in the small blue salon right next door on the right-hand side. And we will have a lunch break until 1:15 to then listen to Dr. Josef Bartončík.
Dámy a pánové, já bych vás poprosil.
Ladies and gentlemen, can you please be seated? We will start our afternoon block.
Dámy a pánové, poprosím.
So, can you please be seated?
Díky. Dámy a pánové, děkuji za usazení.
Ladies and gentlemen, thank you. Unfortunately, we have to make changes because of the meeting of the Chamber of Deputies, and that's why the first speaker of our afternoon block will be Mr. Jeroným Tejc, the Minister of Justice of the Czech Republic. So I'm giving the floor to Mr. Tejc.
Dobrý den.
Good afternoon. This speaker who cannot attract the attention is a bad speaker or someone who's not interesting enough. I'm glad I can be here with you. I would love to spend the day with you, but the Chamber of Deputies is meeting and I was invited to the office of the government in the morning. We tried to convince the representatives of some NGOs and some civil servants who disagree with their transfer under the ministries that it would work better, that the agenda could be attended better. This is very important for the people of our country. We want that those who decide about the factual agenda decide based on the results of the election, the mandate from the electorate, and I believe that the change I explained to them in the office of the government will help it. 10% of those who were not engaged in the debate of the office of the government then left earlier, and they came in order to make a scandal and approach the media. Our topic is justice. Thank you very much, Mr. Koudelka, for substituting me. In the morning part, I want to say that although we are the Ministry of Justice, neither me nor the colleagues are able to mitigate all the problems of the world and establish justice everywhere. And justice sometimes is not objective and unbiased. Sometimes it is biased and people feel that that's the way it is in life. And I wanted the ministry to be unbiased. We work hard on it. A colleague of mine who is in charge of the disciplinary proceedings of judges and in charge of complaints on breach or infringement of law is present here. And wherever we are not convinced that we would succeed before the Supreme Court, we will not complain. We will complain in the severe cases in which we believe that the Supreme Court will accept our complaint. I very much appreciate the fact that we discuss the issues. We have good experts who are able to prepare the cases and the problems so that the deputy ministers and me myself receive qualified information. Mr. Koudelka said that the criminal procedure code is being commented by the stakeholders, and I didn't take my office of the minister not to become popular. I was away from politics for some time, and then I understood that if I want to change things and do the right thing, I cannot expect any applause. Nobody will thank you for good work. I do things that I consider right, and I will continue working this way. That's why we've submitted the amendment to the Criminal Procedure Code. The media are against it, the opposition is against it, but I'm convinced that this is the right step that will lead to justice. I will say that the public prosecutor will be banned not to present an evidence that would help the convince
v smyslu, že má posoudit ty věci a pokud zjistí, že
favorable evidence must be submitted and the evidence must not be concealed. That is beneficial for the culprits, and we defend the communication between the defender and the information that must not be disclosed cannot be concealed. We had to pay compensation for this mistake imposed by the European Court on Human Rights. So we will lay this down in the legislation. Disciplinary proceedings and complaints for breaching the law. I do respect the independence of judiciary, and courts must make independent decisions, independent on politicians and their will, but not independent on the law, on the legislation. We might have various interpretations of the law, but the basic principle is should exclude excessive rulings, and if there are excessive rulings, I will file complaints in some cases. However, I don't have much power here as a minister, so I will file a disciplinary action. So many of you are telling me that we have to file disciplinary actions more often, but we must understand that the judiciary is independent and the minister is not a superior of courts and prosecutors and so on. And that's correct. That would be wrong. The particular political power then might get rid of the inconvenient persons and might pursue their power via the courts. Courts must be independent, but we are all liable, and I want to strengthen the liability of prosecutors and judges in the cases when prosecutors and judges make a mistake. That is, when a satisfaction or a compensation is decided about for their wrong decisions, then it is so difficult to claim these amounts from the prosecutors and judges. So if we could claim it from them, then majority of the judges and prosecutors would work better. So I want to extend the deadline for the compensation for 10 years. Some of the trials take long. Unfortunately, those where the mistakes are made. So we need a longer period. I do propose 10 years, and we can claim damages only if there is a disciplinary breach is ruled out by the disciplinary panel. And I would appreciate that if an expert, independent disciplinary panel assesses that there is a reason, then the Minister of Justice should have a possibility to file a motion to the court, and the court will then issue a ruling. Today it is really narrow. So this is the liability, and I think that I named the most important things that are being debated. Today I have published the family law amendment so that there are no more cases of child deaths like Viktorka case. And change of legislation and change of judges' approach is a long process. It takes years, but we will establish multidisciplinary teams. We will raise the awareness, provide trainings, and we are forming a tool through which we would assess whether there is or is not a violence in the family. Let us hope that it will come into force as of 1st of January. Well, we also want to change something that didn't work well, and that is the experts. Often the ministry as a supervisor focused on formalities, formal mistakes, missing page or wrong wording, wrong heading, wrong figure. This must be correct, of course, but the reports should not be manipulative or wrong. So the ministry has established panels of experts for individual sections. Each panel has got a chair, and together they form a general panel that guarantees methodologies for individual sections, and the ministerial staff will be asking those who understand it. They will be asking, did the expert fail or not? And they will be getting valid answers. Often we were unable to prove that the expert made a mistake, and forensic experts are important. We need them for the custodianships and so on. So it is one of my priorities. We have no silver bullet. This cannot be changed overnight, and in those 5 to 6 months, half a year of our government, we've done a lot. I'd like to praise ourselves. We did more than the previous government in 4 years. Results are important. So I'm about to finish as the light suggests. Yes, my apology, Minister. We have particular cases on our agenda that we want to discuss. So please be brief. We have many contributions that exceed the capacity of our workshop. I wish you every success, and I do apologize for interrupting you. I wish you every success in your work, and now I'd like to hand over to Mr. Bartončík, who will talk about the Slopny case.
Vážený pane ministr.
Dear Minister, ladies and gentlemen, I'm coming to see you from Brno. I have been running an office together with my brother for exactly 30 years. And here, on the premises of the Czech Parliament, and where I can see the teachers, my teachers, who I welcome. Why will I speak about the Slopna case? We agreed with Šalamón Spolek to tell you quite briefly about bringing of evidence in Slopny, which is in general about taking evidence using scent tracing, and we will also speak about retrial, where I also offered my legal services. And it was quite easy or simple how we got around to it. A previous case, which was entirely built on the method of scent tracing. My brother took over this case after an appellate judgment issued by the court in Brno, which favored scent tracing. This evidence was used as corona probatio. My brother focused on the way it was taken. He uncovered quite serious shortcomings. We asked the Czech Agriculture University for a report, and the university carried out their own experiments, their own examination, and they found significant deficiencies. A very high error rate, which did not correspond to the statistics as from the time when law enforcement bodies took this evidence. We commissioned an expert witness statement which said quite clearly that this method, based on the method of police presidium from 2009, is deficient. The conclusions of the expert opinion and of the Czech Agricultural University were quite simple. The Czech Republic at that time was the only country where the specific handler responsible for identification knew where the decisive sample was based, was put in the series of the cans. And the experts arrived at a simple conclusion. I don't want to challenge the work of the handlers or tell that they are deceptive intentionally, but it was proven that the relationship between the handler and the dog really limits the value of the evidence, because the dog is able to sense what will make his handler happy. This is why the statistics in independent examination and examination conducted by the police was so starkly different. Since the case went as far as extraordinary remedies, the Supreme Court refused the extraordinary appeal and fully agreed with saying that the methodology is totally wrong. They issued two judgments in this case because after extraordinary appeal was refused, the case then went to Constitutional Court, and they rejected it too. Scent tracing and identification played a very important role in the prosecution of that case. And in spite of the fact that in practice it is not used anymore, almost, I hope that we will not be seeing such stark cases of injustice. So what was the Slopny case about? A dead body was found in his house in a small village called Slopna. Emergency doctor was called. She inspected the corpse. She did not find that there was anything strange going on. She said the person fell down a staircase. 3 days later, an autopsy was conducted, and the doctor found out that, to the contrary, that there must have been an ingerence of a third person, and suspended this clinical autopsy and gave up the body to forensic autopsy. So law enforcement bodies came into the play and initiated criminal investigation. They took scent traces. Until that time, there was no criminal investigation, and before that time, a number of people got into contact with the corpse, at least 10 people. In spite of that, scent traces were taken and saved. Another strange aspect, the location of the crime was examined, but that only took place after the whole house and the apartment was meticulously cleaned by the family of the deceased. So after this very carefully cleaned place, the place was cleaned, scent traces were taken, perpetrator was suggested, and another one, so there were 2 culprits, and surprise, surprise, the scent traces were similar to those of the culprits. They were, in spite of the fact that they were taken belatedly in a problematic way, and once again, the scent identification was conducted in the way that the handler knew which can is to be marked by the dog, but this was sufficient for an indictment to be filed after pretrial proceedings. So based on this single indirect piece of evidence that was to prove the presence of the culprit or culprits at the location of the crime. This went to the regional court in Zlín, and in spite of the fact that this specific panel of judges, when it comes to criminal cases, they are very strict, but they arrived at an exonerating judgment. This judgment was attacked by an appeal by the public prosecutor. The higher court, for formal reason, returned the case to the trial court, and at that moment, since the scent traces did not constitute a chain of indirect evidence, all of a sudden we found 2 completely new witnesses. One of them were in the same cell with one of the culprits. These 2 witnesses were cousins, and even though the culprit did not confess to committing this crime to anybody else, but to these 2 new witnesses. So this was another piece of evidence as an indirect evidence, and the trial court had to issue a judgment of conviction. An appeal was turned down, as was the extraordinary appeal. I came into contact with the case when I was asked to become a legal counsel for the defense in during the motion for retrial. This case was quite extraordinary, and at that time, scent traces were seen in a different manner according to the new opinion of the Constitutional Court. While the trial court did not have some documents available to them in the course of the first trial, we found these documents. And this first witness allegedly went voluntarily to confess to a different crime to the police. And there's been a lively communication between his counsel for the defense and public prosecutor and the judge who decided about the suspension of the prison sentence. And when you look at all this communication, the only interpretation you arrive at is quid pro quo. I will help you, gentlemen, in this case, and you will get me out of jail. Getting somebody out of jail is very complicated. And the prison sentence before the interrogation of this witness was stopped, and then this suspension was prolonged several times until the point when the present sentence was then dropped, or charges were dropped. And based on the testimony of this witness, my client was convicted. And the other witness told the police quite clearly that they really lied, that they wanted to get out of prison, and the second witness said that he is very upset because his cousin was released from prison and this guy was not. So, and we have all this on tape. We have 3 types of indirect evidence: scent traces, which are very problematic; wrong collection; clearly unreliable method; interrogation of a witness who received. Who was allowed out of prison several years earlier than what he was supposed to, and the interrogation of the second witness, who clearly admitted that he and his cousin lied because they believed that the police would get them out of prison if they tell the police what they want to hear. So there were strange things happening. The judges, I'm very sorry, you have only 1 minute left, says the moderator. Well, the judge called these witnesses to a public proceedings at during one day. One witness apologized to prepare himself for the next hearing so that they could share the information. The judge decided the way he decided, and the appeal court confirmed this. I was very sorry to hear what the Constitutional Court had to say. They only limited themselves to a very formal opinion, confirming everything that the trial and appellate courts did. They did not look at the faulty methods that we protested. They just skipped it. And we are now at a situation that you already had mentioned here right at the start of this seminar. It is very sad that 2 innocent people must spend their time in prison for a murder that they did not commit if the actual perpetrator or perpetrators are still at large, mocking the justice. And it's been quite a few years now, so there will be a statute of limitations in play very soon, so they will probably be free until the end of their days. I believe that this was a stark failure of especially the public prosecutor, and it makes me very skeptical when I see this, if even such an extraordinary level of judiciary as a constitutional court does not reflect its previous judgments. I would like to ask law enforcement and police to be much more careful in how they take evidence, especially when they use scent traces, because if they don't, these methods will be challenged more and more often. I know that these methods, if conducted correctly and objectively, are important to help catch the perpetrators of serious crimes, and it is in the interest of all of us to detect these perpetrators and get them to prison. And I trust that this seminar will also contribute to fulfilling of this dream of mine. Thank you for attention.
Thank you very much, Mr. Bartončík, and I wish you a success in your effort to retrial the case. And now I'd like to hand over to Mr. Jiří Závora, the expert and chair of the advisory body of the Ministry of Justice. Expert reports and their reviewability.
Aha, tak to se omlouvám, já tam nemám asistenta připraveného, aby ji spustil.
Tak já začnu tím.
So let me start. I have few minutes only to explain this complex problematics. So I've been working on it for 18 years, and I only have a few minutes to explain it understandably. So, Danziger, 2011 Israel case that has studied the results of the before lunch and after lunch reviewability. So I hope you will treat me nice.
Děkuji za prezentaci. Snažil jsem se dneska tu přezkoumatelnost.
Reviewability. I take it as even in a more complex way. It is a system system thing. I will be followed by Professor Fennick, who will be more specific. He will mention more examples.
To není úplně asi dobře vidět.
You probably can't see it well, but there exist tragic cases as a manifestation of failure. This is a very depressive seminar, and a tragic case taken from the systemic point of view. It is the error of the system, made by the system, and looking at the errors or defects, like the girl Viktorka who died. It is not just a failure of one expert and one judge. We don't have a solution. We can find a solution if we have a look at who gets and who works with the expert report. It is not only one judge, it is the whole system that works with the expert report. And the control branches, mechanisms related to it, like second opinion, supervision of the Ministry of Justice, committees, advisory bodies, all of them work with the expert report. And we heard from Mr. Bartončík that we have to proceed with due care in this discipline, like sand trace or other. I agree with him, but this is too general. We have to be specific, and we have to specify the due process. It's not only the sand identification, but also other disciplines where you can find out that there is a sensitivity in certain points of the expert report. And in my presentation, in bold letters, you see three basic moments that I'll use as a basis. First, the expert report and its justification, and then work with the assessment by the supervisory body. And there is a good news. In the present framework, the particular steps, we have particular steps that the expert must take, even not knowing about it. It is simply a procedure, and every lay person, and this is the advantage of every judge and barrister, they can ask about these steps. They are mentioned in the decree 503, and if the expert justifies or substantiates the individual steps and explains how he arrived at a conclusion, we can see that the report is reviewable or not. And if a step, any of the steps, is not substantiated, then we conclude that there is a missing step in the analytical procedure. So the expert always carries out an analysis, but forensic interpreter carries out a transformation. So, example, if you cook a meal, you work similarly, but you synthesize because you put things together, and now you might be surprised. Is it so easy? Is it? Now a dramatic pause. And although it is mentioned in the decree, nobody works with it, nobody notices. This is the only criticism that I have. I am often criticized for being overly critical. But have a look at it. A COVID test, we all had it. We all took it. It was a difficult time of our lives, but I will use it because this is an analytical procedure. And if I am a judge or a policeman, never mind, somebody who works with the expert report, I have these critical questions. Source of data. It is the person whom I sample. So, first critical question, common sense. Did you take the sample from the right person or not? From Novak or somebody else? Did you take the mucus correctly? Wasn't the tool contaminated? This is the common sense questions. Data processing. What about the liquid in which you tested the mucus? Wasn't it too old? It's not about the method. It's simply common sense. Is it a good chemical method or not? That's the question. And judges are there only to question the procedure applied by the expert to see whether the evidence is reliable. The analysis is carried out in a white plastic something, lid, let's say, and then we have a result. It's like a pregnancy test. It's also an analytical test. And to be able to read the result, we have to have a guideline which tells us what 2 lines means and what 1 line means, interpretation of the result. And the expert needs literature to make the information precise. And please mind one thing, the conclusion is simply a simple statement of the interpreted results. What do the lawyers read? Only results, usually. And this is a problem because the conclusion, the result, is just a decoration. This procedure that is not being used abroad, unfortunately, and we have it, and we are lucky that we have it. This reflects the steps that must be taken by the expert. It is a chain of problems, like chain of custody and so on. Our colleagues from abroad know that, like our colleague from the US. We've integrated everything in this framework, and we are able to say that in this point there is a mistake, like case of Slopna or scent identification. I would rely on the dog. They can smell well. This is the analytical part. This is the plastic lid. The dog does not fail. But where did they take the sample source of data? How did they work with it? Have they contaminated it or not? Collection of data. How they processed it? Was it put in the cans in the cold? And the mistake, the error just goes through the whole chain. And human psyche is infected by itself. It is the confirmation bias, critical thing. The expert must defend that it looked like it from the beginning, and this is what the conclusion must be. And we have this procedure, but the judiciary does not use it. And let us have a look what we use instead. It is the pink part. We have a task, then the methods, trustworthiness of the expert, length of practice, and sometimes the lawyers use arguments ad hominem against the expert, but it's not a factual debate. Like, where did you take the samples from? What did you do with them? And we will check it out with another expert. How did you interpret the results? Did you separate the results from interpretations? It's like, you know, doctoral thesis. When you were writing your doctoral thesis, you had to take these steps. So then we have serious errors. If we take the pink journey, the expert never fails if we don't ask them about the method. It is just impressions, and impressions cannot decide. And there is a study of Professor Dror and Hampikian from 2011 on DNA. Judiciary says that DNA is a golden standard. It is to be trusted. Don't trust it. It is a gold standard only in the case if in the beginning you have two clean profiles that you compare. Ask Peter Gill, one of the fathers of profiling. In the case of mixture, will you have a result? No, there is an overlap always, and if you have a low template DNA small sample, it is such a huge problem. If you have a look at the Amanda Knox case, Italy 2007, my apology, the last minute, I knew I wouldn't make it. Well, Amanda Knox was accused of a murder of another woman. A small DNA sample was found, which tends to be erroneous. And now look back. Even if the DNA experts don't tell you we used a mixture, DNA sample was too small, then in the end you get a conclusion, and the conclusion will be unreliable, and we are not able to say where they made the mistakes. They won't tell us. And this is what Professor Sanders says. Reliability of evidence is something else than the scientific method used by the experts. So use the decree and expert evidence or expert reports must improve if we use the right method. Thank you.
Já moc děkuji, pane doktore, omlouvám se.
Thank you. I apologize for cutting you shorter, but we have many contributions. I would now like to give the floor to Professor Fenny, constitutional judge, about expert witness statements and their possible abuse. Good afternoon, ladies and gentlemen, dear chair. When I was asked to speak about expert witness statements, or my opinion of it, I really thought about my my working history. I've been a public prosecutor for 15 years and counsel for the defense and judge, and I'm a teacher also of criminal procedure. So the expert witness statements are included everywhere, and my experience with expert statements or expert reports is not the best one. I don't want to criticize the experts, their work, or tell them they must work better, or that the law is bad. I'm just trying to show what I think is bad or about them. These are quite principal errors and deficiencies. Otakar Motail in, I think, 2007, he was an ombudsman, said that the experts destroy human lives. They are not responsible, they are not educated, they take a very long time, and the results do not correspond to what we need them to do. He spoke especially about the cases of children, but it relates to all kinds of procedures. This is quite small. I hope that you can read it. And I highlighted that expert report must not replace the judgment of a law enforcement authority. The expert statement is understood by law enforcement as something which should not be challenged, especially when they themselves committed it. The problem is that this is a traditional practice that has been in place for dozens of years. Law enforcement authorities accept the expert report without any critical view, and only when someone starts to challenge it do we see some criticism, and that will only take place from a certain angle. I don't have a methodology like Dr. Závora. I'm unable to analyze the steps of the experts or define them in a set like he. But I may say that the methodology of expert statements is often flawed, and you can see it at the first glance when the expert takes over as a starting methodology the conclusion he or she is supposed to arrive at, because the expert is used to law enforcement authority agreeing with them. Law enforcement usually has a group of experts who work with them often and do what they're told, and they won't accept those who don't want to do it. And then this leads to a very clear diversion of the number of expert reports taken by these popular experts. If there is then an expert statement commissioned by the defense, that's different. Quite often they also do not examine the questions that were raised. They don't respond to the problems. Part of the questions is left out. In spite of that, these expert reports are seen as unchallengeable pieces of evidence in criminal proceedings. I don't want to speak about my current case because it has not been finalized yet, and I don't want to exert any pressure. But there is a very popular sentence which says it does not have any forensic relevance. That's a very popular sentence. If you ask the expert what he or she means, they will tell you this has no relevance for the criminal proceedings, which is strange because very often the experts don't know anything about criminal proceedings and how important the review of these expert reports is. So they will protest it. Also, experts very often pick and choose only such facts that conform with conclusions of the prosecutor. There's a difference between clinical conclusion and forensic conclusion. The diagnosis is a clinical conclusion, and it should be viewed in the relation to whether it compromised the mental and emotional capacities of the accused. So if the expert says this has no forensic relevance because the person has no diagnosis, that's wrong. Quite often we hear in the criminal proceedings from the expert who does not know how to answer a complicated question. The expert will say, when asked about how is it possible that a clear, very strong stressor did not influence the person, the expert said, well, the person is probably is probably very resilient. Well, that's not an expert's answer. Or you can ask whether the mental state was influenced in the course of the crime when, and this was a theft. The expert will say, well, even small children know that you're not supposed to steal, that stealing is wrong. So, and experts sometimes quote Wikipedia instead of conducting a technical examination. I know that I have to be very fast. We don't have much time. What are the errors of the police? Very often the experts are picked and selected based on whether the police knows them, not according to their qualifications, current scientific work, independence. And the police sometimes does not formulate the question in a neutral way. Sometimes it's a leading question, so then the expert must answer in a certain way. And perhaps in the beginning of the proceedings only a part of the file will be reflected in the question, and then the expert report is insufficient. Sometimes the expert unknowingly, unwittingly takes over the factual framework and then adapts his or her conclusions to this. As for the errors of the prosecutor, the law says that in exercising his powers, the public prosecution service shall ensure that every action is lawful, prompt, professional, and effective. It shall exercise its authority impartially while respecting and protecting human dignity, equality before the law, and so on. But the factual statement is sometimes formulated in such a way that it will conform to the conclusions of the expert. Contradictions between the expert report, witness statements, documents, and are sometimes marginalized or covered up by reference to the authority of the expert or its institute or the institution where they work. There's selective work with reviews. Review report is only commissioned when the expert report is not in line with the indictment. Sometimes the prosecutor discourages the expert from raising certain questions because they allegedly are not important for the judgment. The prosecutor wants to help the expert to answer the questions in a way that plays into the hands of the prosecutor. I understand the prosecutor in a certain way, but the expert report is only one out of all evidence, and we have free assessment of evidence. So expert report is not the single and only evidence that should be used by the court. It's just one out of many pieces of evidence. Then courts, during the main trial, it happens, and unfortunately it happens quite often, that the court shortly after the indictment was filed, the court decides about what happened and how it happened, and then all taking of evidence, including expert report, are adapted to this preemptive conclusion, and the main trial is then transformed into legitimization of the expert report rather than its adversarial evaluation. So it leads to the judge not allowing certain questions, will reduce the number of questions he allows to the expert to raise. That's very bad. And then, of course, the defense, the expert reports commissioned by the defense are sometimes not okay either. Sometimes the defense counsel will pick the expert according to what they need to hear from the expert. The main thing, they get a report that fits their needs. But of course, on the other hand, the counsel for the defense, when commissioning an expert report, it should have the same weight and value as an expert report commissioned by the police or the prosecutor. The problem is if it cannot be reviewed or is incomplete or weak. There are some important points that test the quality of an expert report, and that all law enforcement plus the defense should perceive instructions commissioning where the questions non-leading and where all necessary questions posed. Did the expert have a complete and balanced set of underlying materials? Was the expert genuinely competent in the relevant field? Is the method current, validated, and properly explained? Did the expert state error rates, uncertainties, and alternative interpretation? Sometimes the expert will omit all this. And finally, forensic translation. Did the expert explain what their scientific conclusion means for the facts in issue and the legally relevant question without substituting for the court's legal assessment? It is not up to the expert to provide legal assessment. That's up to the law enforcement authorities. He just has to explain how his method can influence the examination, for example, of the mental capacity of the person. So I really was mentioning especially the experts commissioned during the criminal proceedings, usually psychologists and psychiatrists. We also have other experts, especially in road accidents. I'm very sorry, no time left. The courts accept expert reports without any further deliberation. That is really untenable, and I hope that together with Dr. Závora we will be able to create some better situation in dealing with expert reports. Thank you for attention.
Já děkuji panu profesoru.
Thank you very much, Professor, and my apology to all participants. We promised a debate, and I do promise that if speakers keep their time limit, we can have a debate. But I will hand over to Simona Hinkelmanova, the barrister, with her contribution. He didn't hear he didn't understand, he couldn't say, but he was convicted. Ladies and gentlemen, I would like to introduce to you the case of Martin Fabian. Martin Fabian was convicted by the regional court in České Budějovice Tábor branch in conjunction with the judgment of the High Court in Prague of criminal offences and sentenced to 15.5 years of prison, which he is currently serving in Mírov prison. What is specific about Mr. Fabian? He is a handicapped person with a disability. He is deaf, and he relies solely on lip reading under specific conditions or written text. You have to talk to him slowly in certain light. You have to articulate well and use shorter sentences. Or he can read a simultaneous transcription of spoken language. Mr. Fabian already had this disability at the time of the criminal proceedings against him were conducted. The entire criminal proceedings against Mr. Fabian, beginning already in the pre-trial phase, were conducted essentially without ensuring his right of access to information. He was offered interpretation into Czech Sign Language. However, Mr. Fabian does not use this communication system. He doesn't know it, and no alternative means of ensuring access to information such as real-time speech-to-text transcription were not offered to him. The court took the view under these circumstances that lip reading alone was sufficient and essentially didn't further address whether Mr. Fabian actually understood the proceedings or not. So if he did not respond to statements and ask questions to witnesses, then the court took it as well, silence means agreement. For you to see what was the main trial looking like, we'll show you 2 one-minute videos from the trial. What is your status? Are you married, single? Have you got children? Property, apart from what we know from the file. Can you say? No, personal. That means, are you married? You have a fiancé, Ms. Hrubá. Have you got children? Have you got children? Daughter or son? Can I try? The judge is asking you, are you single, married, divorced? Single. No children. Have you got children? Not yet. Health problems apart from the hearing. So, property. In one report of the file, you talk about cochlear device that you can use for a debate. Have you got it with you? Cochlear implant? Have you got it? In one communication, you talk about it. So do you use it? Does it help you to hear? You mean now? Yes. A while ago, the cochlear implant. Have you got it? Now. Have you got the implant that can help you to hear us? So, undoubtedly, you've noticed that when you speak slowly to Mr. Fabian, he understands, and you have to repeat it several times to him. So in the main trial, the chair of the Senate, the judge, and the defender tried. So at the beginning of the trial, it was known that Mr. Fabian has a problem, that you cannot rely on lip reading. But they continued. And let me show you another 1-minute video of a part of the testimony of the witness. I said several times, I will say nothing new. There is nothing new. They've met. Martin, several people lived there, and the guys knew each other with Milan, and Milan was leaving somewhere, I don't know. He said he was simply fed up. It was not easy with my parents, and he said that there is this new guy who can stay there, and it was Martin. As I said, this is a part of the witness speech, and it illustrates the way how the witnesses stated many hours. I will not talk about the written evidence that were read in a very fuzzy way by a judge. In the first 2 videos, you saw that he had a problem to understand. And now, do you think that he had a chance to understand the witness? Mr. Fabian, in his trial, was not a subject, but an object, merely their object. And this with the full awareness of the entire judicial panel, the public prosecutor, and his then court-appointed defense counsel. He was just a viewer, not a participant. His defender did not meet his obligations. Mr. Fabian was in detention, and he only relied on the appointed defender. Court must ensure a fair process, and during the appellate proceedings, now represented by new counsels, Mr. Fabian argued that he had not understood the proceedings at all, that he had been forced to rely solely on written transcripts of the hearings, which were themselves delivered lately, with delay, and he couldn't meaningfully participate. The High Court in Prague itself, while hearing the appeal, had to recognize that statements addressed to Mr. Fabian needed to be repeated several times before any communication was possible, which is evident from the audio recording of the public hearing. Nevertheless, the High Court in Prague, followed subsequently by the Supreme Court and the Constitutional Court, found no violation of the right to a fair trial. In 2022, when Mr. Fabian's case was taken over by the Shalamon Association, we conducted a detailed analysis of the case based on audio recordings. We discovered that the official hearings transcripts didn't reflect reality, that they are not true, and that the whole proceedings were fundamentally defective. We wanted to provide a fair process to Mr. Fabian. We also obtained an expert medical opinion in the field of otorhinolaryngology by Professor Komínek, who concluded that Mr. Fabian couldn't understand anything. we considered a complaint for violation of law to the appropriate remedy, and therefore we submitted one to the Ministry of Justice together with a detailed analysis of the fundamental procedural defects. We emphasized that the Supreme Court and Constitutional Court decisions in the original proceedings had relied heavily on inaccurate hearing transcripts, and that in our opinion this made such extraordinary remedy admissible, and the Ministry of Justice rejected our request on the grounds that the matter had already been reviewed by the Supreme Court in appellate proceedings, and we possessed an expert opinion and new evidence, so we should instead file a motion for reopening of the proceedings, which is a nonsense now in our situation, but we had no other opportunity. We've filed the motion, we were rejected, and although we have proved beyond doubt that Mr. Fabian had understood almost nothing during the original criminal court due to his hearing disability, we simply were rejected last minute. Mr. Fabian thus found himself trapped in a vicious circle. On one hand side, the Ministry of Justice refuses to file a complaint to the Supreme Court, and retrial is rejected also. So in this case, it is a situation of a failure to provide fair process, and the case of Mr. Fabian proves that we have a big problem in the Czech Republic. After the trial and appellate or appeal, if there are new evidence, the person hasn't got any possibility of remedy. So why don't we amend the section 278 of the Czech Criminal Code that should be amended to expressly include such circumstances as an additional ground for reopening of the proceedings. Thank you very much. If there are any questions, you have 1 minute for the debate. So please let me know, and I would let you in the debate. There are no questions. You can push the button behind your notebook, and we can answer at least one question concerning this case.
Pan se nám přihlašuje do diskuze.
Výborně. Jiří Pavel Pešek.
Jiří Pavel Pešek, Center of Sacral Arts. I perceive this debate as a deeply personal debate. We've been fighting for 30 years to pursue the decision of the highest executive authority of the Czech Republic, Ministry of Culture. That is the case of the devastation. My apology. I hoped you will ask a question related to the presentation. The capacity of our seminar is completely full, so we have a 45 minutes delay. I have no room, unfortunately, for such comments. Should you have any question concerning your presentation, well, yeah, please ask a question. How can we achieve implementation of a ruling or decision of the Ministry of Culture? I am meeting the CEO of the National Monument Institute. What How can we pursue a decision of the Ministry of Culture? This is a question that goes beyond the remit or qualification of the doctor. She is an expert in criminal law. Why don't you use the service of a barrister? So, for the next debate, it is about questions, not comments. I wish you every success, and I hand over to Karla Potůčková, who will have an interesting contribution that is called Inconvenient End Up in Detention. So, over to you.
Ladies and gentlemen, I was asked by the Šalamón Spolek, whom I met in 2025, to tell you briefly about my case. Right at the start, I would like to tell you three important things. In the course of my case, I have asked an expert or an expert psychiatrist 70 times to give an opinion about my diagnosis, and they all turned me down because they did not want to lose their reputation. I approached counsel for the defense specializing in protective treatment, and I approached the Czech Bar Association without success, and the desk of criminal law at the Brno University. They did not respond either. I also tried to file 2 times a constitutional complaint, but failed because without a counsel for the defense, a constitutional complaint cannot be filed, and my lawyers committed a time lapse. In 2005, I started to have problems when I started to work in the teaching hospital in Pilsen from a village, and then they were dealing with the change of education in healthcare. There's been a reform in Europe. My original profession is I'm a clinical psychologist. The lady who worked as a leading clinical psychologist was afraid, and she wanted me out of that teaching hospital in Pilsen. So I did leave, but I remained in email contact with the former head of the clinic, so that we would proceed dealing with my matter. I come from Pilsen, and I thought that this might be very difficult for me. They will want to examine my mental condition. I approached my former boss to help me. The situation took very long. He ran out of patients in December 2013. He went to the police and he charged me with stalking, and the hospital did the same, and the head of the psychology department there as well. I didn't know what to do, so I went to the regional public prosecutor in Pilsen. They wouldn't speak with me. They did not respond at all. Then the matter was being taken up by Karlovy Vary, and the prosecutor decided that they want to assess my mental state in a hospital. I'm educated in this matter, so I knew what is going to take place. 6 months 6 months elapsed. I approached them again to which hospital I should go. They did not know where to send me, but they could remand me in custody. So this is how I ended up in remand prison. From there they took me to Dobřany. That was 18th December 2014. In January, the experts stated that from 1st January 2010, my volition and mental capacities are starkly reduced, and that I have a serious mental illness of a schizophrenic type, and psychiatry came into play. In Dobřany, I was remanded involuntarily in special court proceedings. Karlovy Vary did not mind, and they asked Dobřany to decide about protective treatment. I was kept there for 3 years. I was not allowed to go out, to go home, to bring my stuff, and regional court in Pilsen decided that I must I must go through protective treatment in a hospital. So then I resumed the fight for my rights, but then psychiatry took over the initiative. They decided that I should lose my subjective legal rights and that I should be sent to Kosmonosy, because there was a conflict between me and the Dobřany institution. I had no medication. I only had oncological medication. In Kosmonosy, I attempted to agree with their administration to help me get released. They promised, but the chief doctor Matějka decided against it and decided that my protective treatment should be outpatient now. The court from Boleslavy invited an expert from Bohnice, and the expert did not deal with the medical point, I was not on medication. They wanted me to take medication. They proposed a medication that was not the first choice type medication. I refused, and they asked that I will be put into security detention. That is a special detention for people who committed a crime when they were security detention. So it's for people who commit a crime. Again, expert institution from Bohnice took the matter up. They did not conduct any medical analysis, and they said that I should really stay in security detention. In security detention, the psychiatrists conducted a detailed psychological and psychiatric analysis, and they had me sign an application to leave. this was re-evaluated 1 year later. The judge opened this case, but saying that they will not deal with my case before 2025. I thought that was absurd, and in 2024 I wanted to ask the public prosecutor's office to decide about releasing me, about my release from detention. They filed this application. The court picked an expert. The expert was against my release. So the regional court turned me down. In 2025, I already cooperated with Shalamon. The expert first stated that security detention is to go on, and when he confirmed the expert report in front of the court, he said that it would be possible to transform it to protective treatment in an institution. But unfortunately, at that time, the expert report was not valid anymore. At that time, the expert, even the General Gauch, the head of the security detention, asked for my release. In 2026, I ended up again in Dobřany with a new round of questions whether I should be on antipsychotic drug, aripiprazole this time, not risperidone, and which again I turned down. Now, together with Shalamon Spolak, we are trying for protective treatment to be either finished or changed to an outpatient treatment. 3 more points in conclusion. For a certain time, I was allowed a telephone in Kosmonosy. I attempted to contact some colleagues from my profession because issues of methodology of work are not an issues of one person. There is an association of clinical psychologists, but they did not want to have anything to do with my case. Since I committed a crime which is new in the criminal code, and that is disrupting human relations, the law enforcement doesn't know what to do with it and how to grasp it. From 2021, I tried to contact people who are interested in this methodology, because we speak about providing early rehabilitation to patients of somatic diseases, and we are legally entitled to this treatment. But the field. Thank you for attention.
Děkuji, paní magistro. Já moc děkuji, paní magistro.
Thank you very much for a strong contribution. You stayed within the time limit, so we have the opportunity to ask one question. This is one of the surprises of our seminar. We had her from Dobřany this morning. This is how a dangerous patient looks like. She was detained for her complaints only, and this is the harshest protective measure of the Czech state. And her release from detention was caused by Zuzana's camera. When they saw us with the camera all of the sudden the expert was able to say, well, she's healthy, she's not dangerous. If we would come without the camera, she would be there till now. She has not committed any offense. You were not convicted. You were blamed for stalking, and after 3 years of detention, it is incredible. I'm so glad I got this satisfaction today. I am an introvert and I perceive some of these things differently. Creating a new structure of cooperation between judiciary and the healthcare is so difficult. It is impossible. And Susanna introduced me to a professor who spoke before me, so I have some hope. And the other satisfaction is what I heard from the Ministry of Justice. I wrote them repeatedly and I asked them, can I get a list of experts who are of a quality, who are really unbiased, so that I could ask an expert to help? And I need to know what is their hourly fee. And if we can make this, then it will be really great. Thank you so much. So you can... we have 30 seconds for a fast question. Miroslav Špadrna, Vice Chair of Šalamón, question for you. Such a sensible, understandable speech, I mean, of a normal person. That's so rare. I haven't heard such a sensible speech for quite some time. So why is it dangerous to let you on freedom? Because this detention, security detention, is an imprisonment. Well, in Kosmonosy, I had a telephone and I contacted people. I wanted to improve the position of people in the somatic hospital. Thank you. And now...
Poprosím.
Now I will give the floor to Dr. Špadrna, who will talk about the compensation for victims. Ladies and gentlemen, my name is Miroslav Špadrna and I am a vice chair. I will have to cut down my speech. It will be the shorter one. Compensation for victims of illicit proceedings. In 1991, in Czechoslovak Federation, we adopted the Charter of Fundamental Rights and Freedoms that has become the part of the Constitution. This charter and the Constitution are a catalogue of human rights and freedoms. One of them is a right for court protection and compensation due to an undue process. Article 36 3 refers to the Act. And in case of an illicit detention or imprisonment, it is the right resulting from the European Convention on Human Rights, breach of the Personal Freedom Act. The law from 1998 is the Act 82 that has been amended several times and does not reflect current needs and reality. imposes disproportionate formal requirements on individuals harmed by unlawful criminal proceedings. So decision-making on their demands is made by the courts, including Supreme Court. Victims of unlawful criminal proceedings must face secondary victimization. It is a protracted and humiliating process, full of formalities that deters the victims. The aim of this article is highlight the fundamental shortcomings. The main shortages of the law. The first act on liability for damage was the Act number 58 from 1969 of the collection, which was with some cosmetic changes transformed into a new law 82 from the year 1998. Back in 1969 and later, the people didn't have to pay court fees, and the law 82 from the year 98 came into force in May, and it has changed some terminology. Principles remained the same, and formal obstacles remained in the act that are to the detriment of the victims. The Act does not allow that the damaged person has a right to compensation of cost arising by claiming the title with the Ministry of Justice. You have to simply lodge a claim to the Ministry of Justice, wait 6 months, and only then approach the court. So no change here. Another disadvantage came into force on 1st of January 26, when the title based on illegal detention or a sentence means that you can raise your title only through a form, a prescribed form, or else you are disqualified. And there is no title to the compensation for barrister's fee. This law from 1998, as the previous law from the year 69, contains no positive damages for illegal prosecution, only for detention and sentence, but not for the illegal criminal prosecution. This is missing. And it is interesting enough that although the Constitutional Court mentioned it in 2007, this positive amendment is missing and remains missing. It is an illegal decision, and this is only due to the rulings of the Constitutional Court, and according to results of the ruling of the court, it is stated to be illegal. So question is this the rule of law if the claims must be based on judicature? In the 19 years we have not changed this situation. Another shortcoming is that the law does not talk about compensation for next of kins who were impacted by criminal proceedings of their family member who was in detention or who was sentenced. I've initiated several cases. I asked the family members to approach the courts, and they were rejected. So detention and sentenced is a burden not only for the sentenced person but also for family members, and they don't have a title to anything. The Act 82 from 1998 at the same time has unproportionate conditions to the application of the titles. This is the inequality of rights in breach with the Charter of Fundamental Rights and Freedoms. The Constitutional Court is failing here. The Constitutional Court in 2010 in one of its rulings says that the 6 months period for the mandatory preliminary settlement of a claim with the ministry has remained in effect, and it must be shortened, and it still was not shortened. We still have this 6 months period, and some people already approached the Constitutional Court and they applied a proposal to cancel this 6 months period, and the Constitutional Court always rejected them, saying that they are not a negative legislator. And the Constitutional Court well said that this period must be shortened, and Constitutional Court simply does not want to intervene. This is not a rule of law, is it? What is the biggest problem about this law 82? Very short 6 months.
6 měsíců v případě promlčení na
Statute of limitations for the compensation of non-material damage, like right to life, health, and protection of personality. According to the new civil code,
zákon 82/98 u nemajetku
so is in default after the non-material damage that was included in 26 after the criticism of European institutions. So there is a right to damages, but with 6 months period. Why? 6 months at that time, it was a period for individual complaints by individuals, complaints to the European Court for Human Rights, and we talk here about a title laid down by the Charter of Fundamental Rights and Freedoms. So this cannot be defended. The limitation period is 3 years, and there are doubts about this period. 3 months as a very short period was confirmed by the Constitutional Court in its ruling from September 2016. And the complaints were accepted for other reasons, so they put it on the margins. And I just want to say that There are last 2 minutes. If you want to respond questions, go ahead. If you want to skip the sections, well, at the same time, inequality in rights and court fees from 2017, the fee makes up to 2,000 crowns. The state does not pay such fees. In the appellate proceedings, you don't pay, but given the subject matter of the dispute, the fee amounts to 7,000 or 14,000 crowns. The courts are... The Ministry of Justice does not promise. Excuse me, the speaker is much too fast. The ministries send the civil servants to the courts who know nothing about the cases, and the compensations for illicit criminal proceedings and its length are completely insufficient. The Constitutional Court last year did not decide about indexation of these compensations on the day when they found out that no indexation needs to be implemented. And on the same day, they decided about the unconstitutional character of the judges' pay increase. Conclusion. The damages, and I have to skip 5 pages of my contribution. It is humiliating, lengthy, insufficient. The amounts are just ridiculous in some rulings, as the Constitutional Court stated, but people don't get to the Constitutional Court often. There was no change made in the system, and if we don't accelerate the process, if the victims don't get appropriate compensation, then the Czech Republic cannot call itself a democratic rule of law state, which it does in the Article 1, Section 1 of the Constitution of the Czech Republic. My voice is damaged by the aircon. Thank you for the attention.
Thank you very, very much for keeping the time limit and cutting your presentation shorter. Please look up our website. The presentation will be there in full. Now let me ask Mr. Marek Ficker. He will speak about the abusing of plea bargain and universal witnesses in exchange for a benefit. Thank you for the floor. Ladies and gentlemen, I was invited to speak about the abuse of a plea bargain and about universal witnesses in exchange for a benefit. Some of you may be surprised that there is such a thing in the Czech Republic, but there is, and it's not new and it's not rare. It's been a part of criminal proceedings for quite some time. Abroad, sometimes they call this crown witnesses or other terms. Our Eastern brothers call this institute repentance, and I picked Slovakia for a purpose because they have come further than us. I have a Slovak Information Service report, which is not public. It's from May 2021, so it's 5 years old. And the report then said that the Slovak Information Service found that the Slovak law enforcement authorities, that is police, are inviting people who are in prison to become witnesses in exchange for benefits. These witnesses are either criminally prosecuted, that is in custody, or they have already been convicted, so they're imprisoned, and they're offered various benefits. They will be released from the custody or from prison, so they are influenced. They call this operative cooperation. So it's not that the witnesses would provide information, they are given information, they are instructed as to what statements they should give the court at court trials, and this is how they deal with lack of evidence. And now let's go to 2026 and the case of so-called Čorilovci. There they opened criminal prosecution for this. It took 5 years. They investigate or prosecute a public prosecutor and top policeman. It is a vast, thick file which says that the witnesses were were prepared using training or mock interrogations. Policemen used to repeatedly visit these witnesses. The policemen tried to break them, telling them that they will not release them to spend Christmas with their families, or they were offering benefits. It's not only plea bargain, but other benefits as well, which are abused for this purpose. Let me give you a few examples that I know from my own practice. I came across a professional witness or material witness for the first time in 2010 in case of Toffel gang. Nowadays I defend Pavel Moraň in his crime case. There are several professional witnesses. There are several professional witnesses who corroborate their testimonies. This is very hard to fight against. There's been one poor person who ended up in prison who wanted to be conditionally released, and he was ready to do anything to get out. He was a repeat offender, so he knew it would not be easy. There were 3 inputs. There were 3 high police or prosecutor bodies who approached him. This witness then conforms to the wishes of all these institutions. 3 top institutions promised that they will help him, and he repeated his witness testimony 3 times in a row. When you look at the timeline, it is hard to believe that this was not all connected. Another person suffered through what the Slovaks call a turnaround. He was released from custody for a certain case, but he was immediately re-arrested, brought to another detention, and at the presence of 2 policemen just with him, no one else, he had to sign another witness testimony. And then there was another case when a person was arrested for obstruction of justice. He denied everything, but 2 nights later, he already admitted to committing everything. So once again, he became a cooperating accused, or let's say the repentant, the professional witness who will tell you anything you want. And top policeman, Lieutenant Colonel Jiří Konvalinka, in his doctoral thesis, he defended it with laurels. He writes that in this operative cooperation with witnesses is a legal measure to gather evidence, to receive information. And he proposes to approach people who are in detention or in prison. Of course, you can understand this in various ways, but if you look at such specialized testimonies and how they played out in Slovakia, really you have to ask yourself, what did the policeman have in mind when he wrote this thesis? Unfortunately, this problem was typical for the organized crime unit, and it takes place typically under the supervision of the higher public prosecutor's office in Olomouc. If you want to doubt it, you can file a complaint which will get into the system of the prosecutors. It will go up to Olomouc, and then this criminal complaint will go back to the policeman against whom you filed this complaint. And I'm not joking. This really is taking place. So the standard procedure of justice system is really non-existent. I approached the Supreme Prosecutor's Office and with a question about this, and they answered that this is an issue of that this is plea bargaining, and it is up to the courts who approve it, not public prosecutors. Witnesses are offered various benefits, not only plea bargains. They will be indicted separately from other co-defenders. So my proposal to be brief about de lege ferenda, what must happen, the law must very accurately say who can become a cooperating accused, what can be offered to him, and how can such witness testimony be seen and analyzed and evaluated. In my opinion, this unfortunate practice needs to be really changed only using a legislative procedure. If you have any questions, I'll be happy to answer if I know the answer. I Okay, we have some time for questions. That's great. You're the first speaker who was brief enough to allow time for questions. There's a question for you. I have my question. You respected privacy, but you mentioned also some professional witness who was medialized. There's Mr. Klanica. Have you got into any contact with him? Did you include him into your work? Thank you for the question. I hope that if I answer your question, I will not be charged with obstruction of justice. This has happened to my colleagues previously. Yes, I know about the case of Jiří Klanica. I even saw the media comment about him. I know the case from my practice. Klanica is a person who is seen in many cases. He is seen almost everywhere. He was everywhere. He saw everything. He is a very accurate witness. But unfortunately, in his case, we know quite exactly what was offered to him in exchange for these witness statements. I even know that one of his criminal cases of his was stopped for inexpedience. And if convicted, he would have been imprisoned for 8 years. Unfortunately, he provided a witness statement that was in favor of a policeman. Then there was another case where he was a witness. That was a case of someone else. I want to name that person. There was a damage in dozens of millions of crowns, and the person was convicted to a conditional prison sentence. So there are many cases of this person. It's hard to evaluate. This is outside the microphone, unfortunately. Any more questions to this speaker? Okay, thank you. And I will now give the floor. Thank you. To Professor Válková. She's an MP and a member of the Constitutional Legal Committee. She will speak about the failures of criminal justice system in the Czech Republic.
No comment. No comment. And can I have my PowerPoint presentation? I only have 8 or 9 slides. But we who are active in universities always use the PowerPoint presentation to attract the attention of the students. No such danger. This is just my personal deformation. I would like to point out by way of introduction that there is a question mark. This is not an answer. This is not a statement. You can answer yourself after my presentation. Thank you for Mr. Bock, Mr. Perichevich, and others, other representatives of Shalamon. Thank you for approaching us and asking for our auspices. Libor Vondráček, me, Radek Vondráček gave you the auspices. That's why we can meet here. And this relates to prestige of this renowned seminar. Your questions, your presentations are streamed and will be maintained forever. I don't know whether this is good. I'm talking about myself here. Don't worry, I will not give you a lecture on criminal law, but all of you who are not criminal lawyers, I want to tell you what is the main base and function of criminal law. It is the maintenance of the status quo in the society. No revolutions, whether you like it or not. Before 1989, we maintained the society and the state system. We've got a democratic society, democratic state with a rule of law, as we hope, and criminal law, criminal justice is to protect it, to protect the citizens from those who breach the basic standards, key social standards that were agreed by us. We have to punish them and deter the others from similar activities, from criminal activities. So we all know that, but it is good to get rid of the illusions of the abstract justice. This is how it is in reality. So the first conclusion must be that criminal law in every society must guarantee a certain level of criminal justice that is a pre-assumption or prerequisite for functioning of every state. So the justice that is laid down in a criminal code according to the ideas of the state must meet the expectations of the citizens. You all know this. I will not delay you, but I thought that I must say that. You are reading about the criminal justice, but these are the key stakeholders who are responsible and liable for the justice anchored in the standards or anchored in the law. It is the police, prosecution, and courts who execute the criminal justice system. So it must be that we have to have the independent judiciary, independent expert character and impartiality, and then the practitioners, executors of criminal justice should not damage the justice. The public simply are led to believe that the criminal justice system isn't here. It is, but it is not executed well because of lack of independence, lack of professional independence. And now I'm so sorry that judges believe that their independence would be at stake if they would take professional trainings in Judicial Academy in Kroměříž, where they would learn more about sexual criminality. They don't want any obligatory trainings. They don't want 2 trainings per year. You can see the same people there, and those who should really take the training often don't come. Prerequisites, and now I'm leaving the abstraction and I'll be more specific. Prerequisite for the criminal justice system and its proper function. You can read it yourself, but the second bullet point is more important. We should not make excuses if we are judges, prosecutors, police. We shouldn't say that we don't have conditions. We do. We have a constitution, organizational structure, mandatory expenditures are high. Ample funding is what we receive. I raised an amendment that was not passed. We were referring to this amendment. I was saying that the Constitutional Court would cancel our indexation caps, indexation on judges' salaries, because the Constitutional Court will say that this is a breach of independence. So the legislation lays down the preconditions for independent, unbiased criminal justice system. And now the particular cases that we discuss raise a question whether and how we can find out whether criminal justice system meets its functions and roles. Public opinion polls are influenced by the media, so their answers are not relevant. If you ask a general question, how to punish somebody who committed a robbery, everyone would sentence them to prison. But if you describe what was the perpetrator, how many children he has, everyone then would only apply a conditional sentence. So the medialized cases should be judged with very strictly. As a politician, I often look at the videos. When you see that the offenders video or shoot torture of animals, of dogs and cats, you feel like they should be sentenced for 5 years. And we cannot increase the sentences for torture of animals without increasing the sentences for other corresponding crimes. We simply cannot do that because our jails then would be overcrowded. Particular cases presented to the general audience. Me as a criminal lawyer with a practice of a barrister, that yes, you are right, but without knowledge of a file, without review and research of a file, then as a member of the mandatory committee, I've read too many files. I went into detail. Defenders among you know that you have to read it 5 times and that you have to examine the context, and only then you can trace that there is a gap that simply doesn't work, and often to your disappointment you see that the gap is closed and that the very nice defendant is really an offender. I submitted a complaint about Lukáš Nečesaný, and my people at the Ministry of Justice were telling me, no, because there is a lot of evidence. And I told them, you must, because there is some evidence beneficial for him. In dubio pro reo. We have to give him a chance to find out whether the doubt is that strong that they undermine the ruling, the conviction. So this complaint was accepted and it worked out well. So why do we have thousands of such complaints and motions for retrial when a success is that a court opens the case and attends the case at all? Is this justice? No. Why is it up to the sole discretion of the minister, or his or her courage or activism? We need a system, not a random course of things when it depends on who is the Minister of Justice. Second conclusion, you won't like it. I really believe that the criminal justice system can be only assessed as a framework, and we can only accept that they will assess their work through the review tools, ordinary or extraordinary tools like constitutional claims and so on. It is a process of self-assessment in judiciary. I wanted to establish a judicial council as a minister of justice formed by 2/3 of people outside judiciary that would decide about cases of systemic errors. So my second conclusion is pessimistic, and I thought, well, what are the indicators used to assess the quality of criminal justice system in the Czech Republic? These are my indicators. You can amend them, you can precise them, but they are correct. Professor, just a warning. Last minute. You have one last minute. Okay, and I didn't mention the case as yet. Indicators, you can read it. And the fourth point, the level and way of medialization of a specific case and its impact on perception of criminal justice. Well, this seminar should be an indicator of our current situation. The sensitivity of public is changing, like animal torture. 20 years ago it was perceived differently than today. Is the criminal justice in the Czech Republic fail often or as an exception? Human factor here plays an important role. Human factor is failing. Is it an exception or does it happen often? Insufficient use of internal mechanisms at the court. Disciplinary proceedings are rare. although errors are often, and now the legislative activity, we have a criminal code dated back to 1961. It is obsolete, it is fuzzy. We have 350 amendments to it. To every section there is a number of judicatures, Czech and European ones. It is one of the hindrances to the transparency and fairness of Czech judiciary. Excellent lawyer with good knowledge of formal, procedural and criminal code of the Czech Republic can win a case or trial that should be lost and the offender should be sentenced, or vice versa, which is an exception. So the third conclusion, the last one, is the following. What I heard and what I said, and I wanted to mention two cases that I will not mention, suggest that we have to change something. The perception of justice in the Czech Republic changes for the worse. I will not name the court functionary whom I heard 6 months ago saying, never the Czech judiciary was in a better position than now. Are you talking about the money, prestige, or work? And the response was in all of the dimensions. Money, speed of decisions, and this seminar is so useful. So Renata Vesecká in the morning mentioned that the civil proceedings sometimes overlap with criminal proceedings, and if you don't intervene in time, you have the cases like this custody of this little girl. He was returned to her father, who killed her in the end. So if a criminal file would be requested, she would never go to her so-called parent, and she would survive. I've run out of my time, so thank you very much for your attention. Thank you.
Já moc děkuji paní profesorce.
Thank you very much, Professor. I'm very sorry that I had to press you for time. Let me now give the floor to Dr. Jan Rosák. He will speak about the excesses in criminal proceedings from the viewpoint of defense. Ladies and gentlemen, I was supposed to speak about excessive steps in criminal proceedings, especially from the viewpoint of defense, but not only. You've heard a number of high-quality speakers who mentioned many topics, so I will leave out some topics and I will use some other topics only in the way of examples. When I heard to Dr. Závora, I hope that he will mention his recent technical study about false stamps regarding court-verified documents. The conclusions were shattering because the vast majority, 70–80% of all notaries were unable to identify a falsified or forged document. And then, based on these documents, Czech courts deal with many cases, civil and criminal. 3 years ago, I spoke here about the kidnapping of Mr. Moran, who was kidnapped by his business partner. There was also a document which was legalized by a notary in Ostrava. I don't want to go into any detail of this case. 3 years ago, there was a final judgment in this case. We like the judge in a trial court who is able to fight against an appellate court's decision. In this case, the judge said that he disagrees with the instruction of appellate court and that he will exonerate the kidnappers against the opinion of appellate court. We also keep hearing about the Mr. Schott. The judge, Mr. Babiš, is happy that the appellate court did take some evidence. For the previous case, the appellate court did not take any evidence. That was just a formal hearing. He revoked the judgment of the trial court, made the trial court accept their opinion. We heard Professor Fanik, we heard Assistant Professor Koudelka that this is against the Constitution. The prosecutor did not mind. He did not file an extraordinary appeal. So 3 years ago, we filed a constitutional complaint in this matter. We know that the Constitutional Court is quite stable in their decisions, but they turned down our complaint. We looked at the panel of the judges who dealt with this at the Constitutional Court. One of the judges there is the wife of the counsel for the defense of the kidnapper. We thought that if the assistant judge is biased, then the judge must be biased too. The judges really have their assistants write everything for them. It's a matter of fact thing. The case stayed for half a year at the Constitutional Court. Then there were changes at the financial office. Some changes were made, and the judge became the head judge and explained that the assistant does not have any influence on his work. He decides independently. Together with it, there was a decision of a different judge who stated that Mr. Suchanek is not ruled out because he is not a judge rapporteur and is not the main one, because he is not the decisive judge. This was confusion. This was confusing because they are saying that Judge Suchanek does not take any decision, but there are 3 judges in a panel who discuss the case and vote on the case. And then the same constitutional court tells you that if the judge is not, judge rapporteur does not have any decision power. So that's absurd, but they still rejected our constitutional complaint. If we look at it deeper, the specialization of courts at the constitutional court, that's a problem per se. We keep hearing that the constitutional court should consist of judges of the most various specializations. But why, if they decide in 3-member panels which are put together in a random way, not according to their specialization? So perhaps they do not divide the cases quite objectively. If family cases or other cases are always decided by the same judge. When you look at the case objectively, you file a constitutional complaint, you find the relevant case law, you and hope for the best, but then your constitutional complaint is turned down, unlike the one that you found in the case law. Should not the constitutional court be the unifying body that should always issue the same rulings? So what should counsel for the defense think if they put all their effort into wording of a constitutional complaint, and a judge different than Dr. Fennick gets it, the assistant works it out, and the complaint will be rejected. So this is how you can succeed at the Constitutional Court. A few years ago, you could read in the media that allegedly there are criminal prosecutions as per order in the Czech Republic. I will refrain from naming whoever said that. We all know it depends who is part of the motion that you file, to who it comes, and so on. Let me go back to the case of the kidnapping, when the business partner has been wiretapped for a long years. We keep hearing that the criminal case must go to Olomouc, and when you look at what the higher court in Olomouc then did, how they blatantly intervened into the decision of Judge Koudela in Brno, this was terrible. And a district prosecutor would not dare to legally interpret a certain case. When you get to the higher prosecutor's office or the organized crime unit, there is not a problem. They will always find a witness. Every sort of low positioned prosecutor would never go to the court with a witness who is false, but these higher prosecutors do it without any problem. I believe that in Moravia, under high public prosecutors in Olomouc, they even go after the defense lawyers. he was prosecuted for motions against policemen and prosecutors. So he was, in return, he was criminally prosecuted. Fortunately, this was then dropped, but still it damaged him. And the police unit in Holešov wrote to all other policemen and public prosecutors in the Czech Republic, so they know that this defense lawyer is a bad person who is now criminally prosecuted. We heard that complaint for the violation of law should be rare, but in my opinion, it should be possible because it's necessary. Because sometimes you cannot get justice in front of a Czech court when every Czech court decides in a different manner. So there is constitutional court to unify the case law or the Supreme Court. So if there was a closed system, we would get no justice. Now, a few specific words to other excesses. Sometimes house searches are a problem. You don't need much to conduct a house search. The person doesn't have to be criminally prosecuted. It is okay if the policeman asks for it or a prosecutor asks for it, and you can go do the house search. The person whose house it is cannot really fight it. And then where can you complain? At the prosecutor who filed the motion for the house search in the first place? You are trapped. Recently, I saw a document about a house search. You would expect it to be justified. It was allowed on the basis of a policeman's letter that he heard that the person grows marijuana. He added a print screen and claimed that the person has a tree of marijuana in his garden. So this is how the law enforcement system allows for a house search. Another interesting thing, there is a house search after 3 years of criminal prosecution. In a specific case of Mr. Jiří Vračka, the court asked for a house search 3 years later after the criminal proceedings were commenced. What did they think they will find? Well, they did it this way. You would think that the house search would not be allowed. It wasn't allowed. So they dreamed up a different crime, and for this different crime, the house search was allowed, and then then they found some interesting evidence. However, that served the first case, not the second case. They couldn't find any evidence. They needed to get into his place, so they dreamed up a different prosecution, and they went to that home. They had a list of documents they wanted to find, but they found documents regarding the original criminal case. So a house search, which otherwise would never be allowed, did take place because it was allowed for a different criminal case. How is that possible? Well, it is possible because it has been adjudicated for a long time that documents secured during a house search can be used in other criminal cases as well, which makes sense to a certain extent. But what took place is a blatant violation of criminal proceedings. You cannot circumvent the law by dreaming up another accusation. And one last idea, we have no time. Okay. Wiretapping. We had a criminal case which was 10 years old. It started and ended at 2010. 10 years later, in 2020, they started to prosecute the person for a different crime, and they asked for wiretapping. Do you think that they had the hope of getting something 10 years later? Well, the courts allowed it. And the wiretaps stayed on for the whole year. They did not find anything, but then they had an official recording based on which the police started to investigate fraud, money laundering, spreading of an infectious illness, abuse of an official person, and such. So this illegal cherry picking resulted in multiple accusations and charges raised after they wiretapped the persons for the whole year, and it did not regard the whole case. One more sentence, that's it. For whoever wants to hear, I can explain things after this seminar is over. Thank you.
Já se panu doktorovi omlouvám.
My apology, Doctor. Thank you very much for your last sentence. I believe the explanation will be provided. And now, Mr. Dimon, can you mention the media and their influence over the criminal proceedings? Ladies and gentlemen, thank you for the invitation. Hello, John Buck. I will be very fast because we've run out of our time. Thank you very much for the opportunity to make a presentation. I have no long presentation because I only substitute somebody else. Media and criminal proceedings, the impact is considerable and negative. That might be the summary, but I will elaborate. Negative impact on the criminal proceedings is not only a feeling impression that we journalists and lawyers have. It is a statement or judiciary recently arrived at this conclusion as well. The Supreme Court has recently cancelled the preparatory proceedings and stated that the presumption of innocence, which is a prerequisite, it is mentioned in the Constitution, it is laid down in the international conventions, and it is an academic value in the Czech Republic. This is the statement of the Czech Supreme Court. Serious statement. And I wonder how comes that the Ministry of Justice doesn't reflect it in the compensation bill that it prepares. Well, the media influence on criminal proceedings is negative because as 14, 15, 20 years ago, it was ad hoc leakages from the files that were attributable to individual policemen and journalists. Now, from 2012, 2013, It has become a way of working, or not of the police, but of some public prosecutions and public prosecutors. Those of you who is familiar with the state prosecution activities, I don't need to even mention who has introduced it as a way of working. Lenka Bradáčová admits this in the interviews. In response of the Rad case, the public prosecution changed its policies and approach to media accusation. So you can be acquitted, but exonerated, but it's good for nothing, because the public opinion has been formed already. The general public has no doubts about your blame, and the media that charged you together with the prosecution don't inform the public about the exoneration. So let me mention the Tamara Hlavková case, a civil servant, former civil servant from Borovany, head of the construction office. In 2010, she issued a permit for a preliminary use of construction, which has become a permit to for the solar power plant, photovoltaics simply, that allowed better proceeds and profit for the owner. The law enforcement bodies started investigation. She was accused. Media informed about it. She was medialized. Media said that she was bribed. The damage exceeded 200 million crowns. The public prosecution in Olomouc carried out a supervision over the case. Media have asked the employer of Mrs. Hlavková how comes that she has not been fired, laid off. She lost her job very soon after that. The first instance court has exonerated her. The second instance court has charged her, and after 9 years in 2022, the Supreme Court has decided that she was innocent, and Brno court has exonerated her. So this is the fact that the criminal procedure was a nonsense. Mrs. Hlavková didn't have a power to allow a connection of the photovoltaics to the distribution. It was a preliminary approval of the construction. So it was really a nonsense, and it might seem that it was a good ending, happy ending, but the problem is that Mrs. Hlavková got cancer twice. She had a difficult transplant surgery. She had to fight for her life twice. Her health is no good today. I don't know, is she still alive? That's a question. So she was exonerated. The courts disagreed with the Ministry of Justice opinion. She only was compensated with 100,000 crowns for those 9 years and completely ruined life. Courts have ruled out that she deserves several millions of compensation. information, but the Ministry of Justice disagreed. It said that she was not a public official, not a politically active person. Her case was medialized, but it was only a minor medialization, and it was not proven that her health problems were caused by the case. So she has put it to court again, and she wants to prove that her health problems are caused by the case. It is a scandal. The Ministry of Health should the Ministry of Justice really should change their approach to this case. The ministry can also control the prosecutors. It was not a building permit that Mrs. Hlavková issued. It was just a preliminary permit. The defenders kept saying that, but the public prosecutor from Olomouc was not punished. He was promoted, and today he works for the European public prosecutor. So this case is a model case. The ministry should really do something about their approach to the victims of criminal offenses and leaks of information from criminal proceedings, and the career growth of some public prosecutors. They should also consider whether they should not change their approach. They should change their disciplinary measures. They should be more active. I know something about that. I am in Olomouc and I monitor the disciplinary proceedings there. Thank you very much. No microphone, sorry. No microphone, but we're hearing that it should be a political crime.
Já děkuji panu čestnému předsedovi.
Na to řeknu jenom jednu věc.
Let me say just one thing. It's impossible to at least get an apology from all those who participated in this unlawful treatment of that person. They say that the law does not stipulate that they should apologize, so they won't. I think this is monstrous. And that's all I will say. Thank you very much for respecting the time limit. Our seminar is closing to the end. I will now give the floor to Dr. Ivana Spoustová, and I want to apologize. Dr. Marvanová, the Senate is in session, so she unfortunately cannot participate, so yours is the floor.
Dobrý den, já bych trošičku měla...
Good afternoon. I should speak about the criminal justice system with the Guardian Justice, and if we are to end up on an optimistic note, because I will be presenting a judgment of the European Court for Human Rights, well, we won't finish in an optimistic manner. I will speak about Mr. Novak, father of 2 minor children. He and his wife decided on shared custody, and this worked until the mother decided that she wants things different. and she decided to move away from Brno to Prague, 200 kilometers away. At that time, the father tried to use all measures, proposals for interim measures for her to come back, or at least the children would come back. He tried to resolve the situation always because he had very nice relationship to his daughters. The guardianship bodies did not intervene. They thought that the conditions of the children and their situation are okay, so no intervention is necessary. And sometime later they decided that the children got used to living in a different place, and an intervention would be detrimental to them. Then this was followed by a complaint to Constitutional Court. We got to the case when again he was fighting for a longer meetings with his children, because he was limited only to holidays and vacations. At that time, the mother accused him from improper behavior to one of the daughters, and she decided that he must not see his daughters at all. The justice system did not intervene either. Then we asked for the children to be removed from her, at least for the summer holidays. The children responded quite naturally to the father. They were happy to see him. There were assessments that he did not commit anything wrong. He has no improper properties, and both daughters love him dearly, which the children presented, so there was no reason to prevent him from seeing them. The European Court for Human Rights defended him. This should be a breakthrough decision. There was a unanimous decision by this court, which does not happen always, and they criticized Czech courts for very reluctant steps taken, not defending father's interest and rights to a family life at all. The case is not over as yet, unfortunately. It is still in front of the General Court. As soon as the judgments are final, we will take the judgments to the Constitutional Courts and we see what happens. Nevertheless, the government authority, representative who represents the Czech Republic in front of the European Court for Human Rights, if you would expect that person to admit that the Czech Republic made some mistakes, he said, as we saw on Czech TV, that the Czech Republic must admit a violation of right to family life and pay damages. He said that this is not a defeat, that this is just an option to improve the rights of people in this country. Well, if we are to improve the lives of people in this country by taking all problems to European courts of human rights, we will have the government pay more and more fines. That's not ideal. And the link to criminal justice, after the mother finally was fined by trial courts for not respecting the judgments, there was a criminal prosecution for obstruction of justice, but it was stated that she committed a minor offense. She was convicted to a conditional sentence and psychological evaluation, and they did not imprison her. And as for the links to other cases, in many cases, the judiciary is much too busy. They intervene into guardianships or not enough. The subsidiarity of criminal prosecution principle is not applied, and no one is interested to help the minor children or the parents who have a hard time. There is a client here. I also had a different client, contrary, when the father took the children from Prague to Brno, making it impossible for the mother to exercise her parental rights. It is not always possible to turn to the European Court for Human Rights. We try very hard. We can never guarantee success, but I'm very skeptical when I hear from the Minister of Justice that he is not sure whether the complaint for the violation of justice, that it is going to be up to him to decide. This should be up to the people who have that task. We have very sad case law about these family affairs. In guardianship proceedings, the children are represented by just social services, and it's not of high quality representation. Thank you for attention. It's not optimistic with what we are saying goodbye. Hope this decision of this European Court will help at least the future families in problems and will make the Czech judiciary system to speed up their decision making. Thank you. And if there's time left, I think we should really leave the time for evaluation of the whole seminar.
Thank you very much for staying within the time limit. So I would like to ask Mr. Petr Sadovsky to come to the rostrum, the chair of the subcommittee for the penitentiary of the Czech Republic.
Dámy a pánové,
Good afternoon. I just learned that I am the last speaker, so I will cut down my presentation. Everything that was mentioned here, everything about the courts and judiciary, of course, impacts the prison system. And I am I see the last part of the chain. I see what's happening in prisons, how the prisons behave, what systems they use, and what problems they have. So now the most serious problem is that they are overcrowded. In some specific regimes, we reach up to 110% capacity of prisons, which is alarming if you take into account the infrastructure of these detentions. We've got 18,967 people in prisons. This is 95.7% of the capacity of 19,815 places, out of which 17,235 are convicted, 1,600 are just in detention, and 120 in the security detention. Change of the system of we have a concept from 26 to 35 for 1 decade. We've invested 29 billion in it. It should change the prisons, the work with the sentenced persons, digitalization, modern technologies, and much more. In order to improve the imprisonment conditions, we have to cut down the number of convicted persons. One sentenced person costs us 2,000 to 3,000 of crowns per day. It is 13 to 14 billion crowns per year. It's such an amount. That's why we have amended the criminal code, and the amendment allows the courts to impose alternative sentences. I will not go into greater detail. You know the details. It might be the obstruction of decisions and so on. Alternative sentences really can be imposed, and we don't have to use detention at all. It is up to the judiciary. It's not up to me. I just represent the prison system. So that's why we came up with the concept, and in the next 10 years we will try to introduce change. We have 70% of repeated crime. This is a huge figure. We should consider it. I will not delay you. I just want to conclude saying, please come and see the repeated crime movie. We have a music band, Highland, and together with my colleague Eda Rovensky, we shot a movie that should help the sentenced persons to understand that there is a better life outside. We had 5 concerts in 5 prisons. This is a documentary movie that we have, and Orbis, multiplexes and others are interested in our movie. It will be shown here on the screens or in the Chamber of Deputies after the seminar. Yeah, I hope you'll like it. Thank you.
Děkuji panu.
Thank you so much. And we had a debate on our agenda or not? Well, if not, this is all. Thank you so much for taking part in this seminar. Thank you for being interested in this topic. Let us hope that we can influence the development of the Czech judiciary, and let us hope that we will be able to inspire the legislators and tell them what to solve and how to proceed. Thank you so much. Have a good afternoon. And Miss Válková once or asked for the opportunity to approach us as a host of this event. Our Constitutional Legal Committee is hosting this event. Mr. Vondráček is not present. So I want to say that we don't want to be a victim of the criminal justice. Robert Temple was a victim. I visited him either in Rinovice or in Bělušice, I don't know. When I left his cell, where he was alone as a disciplinary measure, well, I couldn't, complain, but I told them, be careful be careful. We will pay high compensation, high damages one day. And they looked at me as if I, fall from the moon. So this is a life proof, an example of the fact that the criminal justice makes errors and mistakes in the Czech Republic. So now I can tell you that we will have a lady ombudsman, ombudsperson, 2 women were nominated for the second round. 2 women were shortlisted. So 2 women are shortlisted out of the 5 candidates. Kostolanska and Šimáčková Laurenčíková are the ladies who were shortlisted. So we will have an ombudsperson. So can we say yes, the criminal justice system is failing? Do you have the answer? Is it yes or no? Let us vote. Thank you, Robert Temple, for showing us that in some cases we are failing. Thank you very much for your attention. Thank you, Libor. Thank you, John Bock. Thank you, Mr. Perichevich, and thank you, our moderator, Mr. Mach, for a wonderful moderation. And I hope it was not boring. And my last point, we will have more seminars with a similar topic, as we can see that the political attention is there and the general public needs to exert pressure. I want a new criminal code, or criminal procedure code, and Mr. Tates, the minister, doesn't want it, so maybe you can help.
Tak ještě, než budete odcházet, můžete zůstat.
Before you leave, let me explain that you can stay on because we will be able to view a video film in the main hall of the parliament. You can enjoy it. If you were able to stay up until now, that's great. And the film will be a goodbye. It will be introduced by Mr. Sadovsky. Thank you very much to all the speakers, and this will be the end. Ladies and gentlemen, let me ask you once more and invite you to this film. You can see it in the screens. It's quite a raw view of the inside of prisons viewed by ordinary person. If you can spare the time, I'll be very happy. Thank you.
Já jsem Eda Rovenský, frontman, rapper, textař.
Jsem Kuba Moulis a jsem zpěvák, občas zahraju i na akustiku.
Čau, jsem Kuba, jsem bubeník a jsem z Brna a to má každý rád.
Já jsem Honza, jsem kytarista, dělám back vokály.
Já se jmenuji Vítek Coufal, pocházím z krásné Kutné Hory a jsem nejkrásnějším členem kapely Highland. Snažím se hrát na basu.
Highland je asi nejzajímavější mladá kapela v České republice.
Highland je kapela Vysočina.
Highland vznikl cca před 3 rokama, kdy Eda se sbíral partu bláznů a od té doby brázdíme Českou republiku.
A ještě Salám je Vysočina.
Tak a vzhledem k tomu, že zaznělo, že se někteří musí rozloučit, tak dáme teď tak 10 minut pauzu na rozloučení a pak pustíme film do většího klidu.
VPA Prison Tour bych definoval jako velkou výzvu.
VPA je WordPress Aviation, což je plzeňská firma, která mimo jiné zaměstnává vězně. Prison Tour protože máme 5 zastávek ve věznicích.
Prison Tour by mělo upozornit na recidivu, což je, že ty vězni se vrací pořád zpátky. 70% lidí, kteří se dostanou z kriminálu, se vrací zpět. Jako číslo 70 je průser. Očekávám od toho, že se trošku podívám pod tu pokličku vězeňství a vlastně sám nevím, co čekat.
Zároveň je to prostě výzva, to mě baví.
Zvráceným způsobem se na to těším.
Vás se spocený, ještě jsem tam neviděl od vás.
Raz, dva, tři, hajle!
Já jsem dostala 27 měsíců za loupežné přepadení.
Tak ve výkonu trestu jsem bohužel po třetí.
A něco kolem 3 ještě teda mám do konce.
Prostě já jsem měl problém ten, že jsem prostě bral drogy venku.
Drogy vlastně a krádeže.
Já jsem tu holku svítla.
Kradla jsem poměrně dost dlouho, kradla jsem 17 let, už od 17.
Tady ve věznici jsem podruhý.
Ten trestní rejstřík už nebude prostě čistý.
Tady tě vlastně vypustěj a jako čau.
Ale normálně běžte na vrátnici, když jste jakoby první dodávka s technikou, ať projedete, že? Ale klidně jim řekněte, že máme 25 minut. Jo? Máme 25. února a pro nás dneska začíná VPA Prison Tour.
Když poprvé přišel tenhle nápad, že realizujeme tour po věznicích, tak jsem si trošku vyděsil, že vůbec netuším, do čeho jdem. A jsem fakt zvědavý, jak to všechno dopadne, jaký to bude, jaká bude odezva těch lidí. Právě jedeme na naší první zastávku, to znamená na Bory, do Plzně.
Okolo Boru jezdím celý život. Máma mi říkala, ne, že tam jednou skončíš, no, tak tam jedem, no.
Já mu nestíháme vůbec.